Got it. Okay, give me 1 second while I take care of something real quick. Okay. So, you wanted to call Carlos Valadez, Mr. Garcia, Julio? He might be in another court, no?
I'm sorry, Judge, were you calling me?
Carlos Valadez, did you want to call that?
Yes, Your Honor, please.
Carlos Valadez, are you present in the hearing?
He's present, Judge.
Yes, sir. Yes, my honor. I'm here, sir.
Carlos
Your Honor,
Valadez, present in the hearing.
I spoke to Pete on Friday, Judge. He extended an offer. Carlos was going to be part of the drug court program that we haven't really gotten off the ground there in Zapata.
Well, we're actually, I was going to tell you that, yeah, obviously I was not a part of that. So since all of that has sort of transitioned to, well, to Judge Garcia down here in Webb, I went ahead and volunteered to go ahead and take care of that in Zapata. So we are going to go do it in Zapata. We're going to set up a docket, and we're going to probably do it through Zoom for now. But I still need to get together with the drug court personnel. So that's where we are with that. But we are going to launch it, and I'm going to be the presiding judge on it. And then even though Judge Garcia is doing it down here in Webb, I went ahead and offered to go ahead and do it in Zapata. And even though that wasn't the original thought behind it, but I think that if I do it that way, I think it'll help the program here in Webb, and some of the resources that we have here will be available to those folks that need it down there in Zapata as well.
Judge, is there a timetable on this, Judge?
No, but I think everything should, as long as I have all the information. We know who the defendants are already because Pete had a list of them. I think you did, right, Pete?
I did, Judge.
Judge, and we can actually start a new list. I mean, the cases keep coming in.
I need
So
to meet
some of
with,
the same guys.
yeah, I'll meet with the drug court personnel here, and then we'll set up a calendar for it, and then we'll start calling them in to get processed.
Well, Judge, with Mr. Valadez, he was possibly going to be part of that docket. So, but nonetheless, since we weren't sure, Mr. Garza had extended an offer to me. I was going to pass this case to so my client could determine whether or not he wanted to accept the offer, and there's a good possibility that he will. But if he qualifies for the drug court program, Judge, we may want to reconsider. I'll have an opportunity to talk to Mr. Garza and see whether or not Mr. Valadez is a candidate for that program.
I'm gonna set him for October 22nd at 9, but he'll be probably contacted before that.
Okay, Judge.
All right,
I'll talk to Mr. Valadez. Thank you, Judge.
Mr. Valadez, you got that date? We're muted, sir.
You're on mute, Carlos.
What was the date, sir?
October 22nd at 9, but we're gonna contact you before that with regard to the drug court program.
All right, sir. Thank you, sir.
Thank you.
Thank you, Your Honor. That's all I have. May I be excused?
Yes, sir.
May Mr. Valadez be excused?
Yes. Of course.
Thank you.
Thank you, sir.
Okay, Edward Castillo. Good morning, sir.
Hi, Judge. Good morning.
Good morning. You have I'm not sure that's for this afternoon or for today. Or for
My
the-
understanding was for this morning, Judge, but I
What's the
could
cause
be-
number?
Yes, Your Honor. The cause number is SE 2021-2.
No, that's not here.
Judge,
That might
it's
be-
case
that might be a
number
different calendar.
11413.
11413,
Yes,
but that's civil or family?
family page 7.
Okay, thank you. 11413, in the interest of Santiago Guevara, an adult missing person. Oh, Mr. Guevara, your client wants to become the receiver of that. Can you tell us
Yes, sir.
why?
Yes, Your Honor. Good morning again. And yes, the reason here is that his,
Do you have Pepe Guevara there?
yes, Your Honor, he should be here. I see him. There he is.
Pepe Guevara with Don Antonio Guevara. You're muted, Mr. Guevara.
There. Good morning, Judge. How you doing?
Well, the first thing I want to make sure is to say hello to your dad, because I hadn't seen him in years and he looks really good, but your camera's off now.
My camera is off. Okay, now let's see if I can get this back on.
You just have to go to
Video.
the one that says video, yeah. And then just put the video back on one of those options you may have there.
I just did, Your Honor.
Hold on, let me do it this way. Right there, click on whatever I sent you there.
Okay. It says lost video, and then it says start my video,
There you go, click on that.
but it doesn't want to start.
That's okay. I got that glimpse of you all anyway. So in any event, so Mr. Guevara, your lawyer, Mr. Eduardo Castillo, is here on an application for a receivership for Santiago Guevara. If y'all could just please listen in. Mr. Castillo is going to tell me what your idea is.
Yes, Your Honor. Very
And
brief.
also what the need for it is.
Yes, Your Honor. Very briefly, I guess for purposes of the record, I'll identify the parties just to make it a little smoother and easier. So first and foremost, the applicant is in fact Mr. Jose Luis Guevara, who the court a little while ago referred to as Pepe Guevara. Mr. Pepe Guevara's father is also one of the, I guess, interested parties in this matter, Your Honor, and which is Antonio Luis Guevara. And there is a person who is Antonio's brother, Santiago Guevara, who has gone missing, Your Honor. And at the time that he went missing, he was residing with applicant in Zapata, Texas. The applicant, who I guess is the nephew, right? Mr. Santiago Guevara went missing. He was approximately 80 years old at the time that he went missing. But more importantly, he was suffering from memory loss, Judge. Mr. Santiago Guevara does own real property in Webb County. In the application, I put the legal description of the property as replat lot 5A, block 112, Eastern Division, Judge, in Webb County. To the applicant's understanding, there are no mortgage liens or ad valorem taxes that are owed, and that's due largely in part because the applicant has been paying the property taxes, Judge. It is Mr. Guevara's understanding that Santiago Guevara receives 2 monthly incomes from 2 different sources, specifically Social Security benefits and retirement benefits, and that Santiago Guevara may have a bank account with IBC. The need for this, Your Honor, is because there is a danger of injury, loss, or waste. So with respect to waste, Judge, it's our understanding, or the applicant's understanding, that there was an unknown individual that is withdrawing from funds from this IBC account. And so to prevent the waste, we are asking this court to grant this application. In addition, it gives Mr. Guevara, applicant Mr. Guevara, the opportunity to preserve the real property that is owned by the missing person. And it is our position, very respectfully, that if my client is not appointed as an applicant, as a receiver, that Mr. Santiago Guevara's estate will suffer irreparable loss. My client is not.
What do we plan to do with the funds or whatever is collected?
My client intends to preserve it for Mr. Guevara, and the only thing that would be withdrawn would be any type of maintenance for the home, which would be perhaps ad valorem taxes, Judge. But other than that, as far as the financial aspect, it would not. Mr. Guevara has his own assets and income. Does not need. He's not asking that he be paid by Mr. Santiago Guevara's estate or reimbursed, other than just reimbursed for any out-of-pocket expenses that he may have. Additionally, Judge, Your Honor, I'm sorry, I interrupted the court.
I just kind of want to know where we were going with, if you wanted a hearing on it, because I'm about to finish this docket, and then I'll come right back to you and give you like I'll give you like 5 or 10 minutes to present your evidence, and then I'll rule on your request.
I apologize. I misunderstood the judge. No problem, Judge.
I'll be right with you.
Yes, sir.
Okay, so let's see. I'm trying to make sure I don't skip anybody here. Is it Jesus Rodriguez?
Yes.
Who is that? Who's here on the Jesus Rodriguez?
Here, Judge, present. It's a petition for an adult adoption.
For a what, sir?
Adult adoption.
Ah, okay. And are you doing it pro se? Who are you? Are you trying to adopt somebody?
Yes, Judge.
Who? Mr. Rodriguez. Is he frozen? I think we lost him, right? We lost him? Okay, I'm sure he'll
It
come.
looks like it, Judge, and on the chat, he put Jesus Rodriguez and Helga Vela, and there is a Helga's iPhone.
Is Helga Bella there?
Sorry,
Yes.
Judge, I got disconnected.
That's okay. Helga, are you there?
Yes.
Okay, let me see if we can spotlight you and Mr. Rodriguez. Okay, so Jesus Franco Rodriguez and Monica Rodriguez want to adopt Helga Elise Vela, yes?
Monica Rodriguez is her biological mother.
I see. So you're the only one that has to do the adoption. Okay, here we go.
Yes, sir.
How old are you, Miss Vela?
19.
Okay. Please raise your right hand, both of you, and be sworn. You swear testimony you're about to give here in this hearing will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, I do.
Miss Vela?
Yes.
Okay, very good. Put your hand down now. Okay, so you're asking that you be adopted by Jesus Rodriguez. Jesus, can you tell me a little bit about your relationship with Helga?
Yes, sir. Right now I'm her stepfather. I'm married to her mother. We've been married for almost 3 years.
So you've had a relationship with his mom, been married with her for 3 years, have a relationship for a little bit longer than that. And Helga, Miss Vela, has been living with you all throughout this entire time?
Yes, Judge.
Okay.
Yes.
So before the amount of time that you were married, how long did you all see each other, a date or whatever it may have been?
Probably 2 years, around 2 years.
Before the marriage?
Yes, sir. Yes, Judge.
Miss Vela, the relationship with your father, with your biological father?
No, never.
You never had
Never.
one? Never had a relationship with him?
No, never had a relationship with him.
As a child growing up, when did your parents, when did you all separate? When did
No, it was just my mom.
Just your, all the
Mhm.
family was just your mom?
Yeah.
Okay. And so how did this come about, Jesus wanting to adopt you, you asking him? How did that come out?
No, he asked me, but I've always wanted to, for him to adopt me because I see him as my father, and he's been so great to my mom and I.
All right. Do you have other siblings?
No, I'm the only one.
All right. So you are asking that, you understand, Mr. Rodriguez, that once you adopt Helga, that Helga would be considered like if she was one of your, obviously like a child, you'll be able to, all the legal aspects of that a child can have with a parent, even though she's an adult, more than anything else, like if you happen to get sick, you're in the hospital, she will now, and they only need family members are allowed, she'll be one of the allowed people that are allowed to see you. And vice versa with her, you'll be her dad, so you'll be able to see her at the hospital and stuff like that whenever they close things down for only family. That's a benefit of things. Also, of course, on your insurances and stuff like that, sometimes they do require that, sometimes they may not, but that also is a benefit. Also, if you happen to, either one of you happen to pass away, without a will, you'll now be in the line of descendancy in distribution, inheritance rights. That will always be there as well. There's so many things that are involved in that, and which you cannot take back. Once it's done, it's done. You understand that, Mr. Rodriguez?
Yes, Judge, I understand.
And that's what you want to do.
Yes, Judge.
Ms. Vera, same thing with you.
Yes, sir.
Very good. I will approve your request.
Thank you, Judge.
Thank you.
Today's the 30th, 31st, 30th. Right? Oh. And let me go ahead and sign this. So let's see. And your name will now be,
We're not requesting a name change, Judge.
okay, she's gonna continue with Bella.
Yes, Judge.
All right. Real. Thank you.
Thank you,
Congratulations.
Judge.
Thank you.
So, let's see. Jonathan, we got Brenda Anderson. Is she still there? On,
Here.
Anderson, good morning.
Good morning. A couple of cases. One is on the criminal docket.
Okay.
Noé Alberto Sanchez, cause 2633.
Noé Alberto Sanchez, are you present?
Yes, sir.
Okay, Mr. Sanchez is present at the hearing, and you're at a motion setting. Any agreements?
No motions at, we could just have a setting for plea. And I'm still in discussions with Mr. Guy regarding that, Judge.
Ms. Anderson, this is the one that I agreed to refer to pretrial diversion for a year?
Yes, yeah.
Okay. Judge, this is a state jail possession, a very small amount. I've agreed to refer him to pretrial diversion for a year with drug awareness classes. We should be making that referral this week.
Mr. Sanchez, you're gonna receive a call. Do we have his number, Monica?
No, Your Honor, I need his phone number, please.
Give me your phone number, Mr. Sanchez.
It's 956-480-1409.
Probation is gonna be calling you for the pretrial diversion program, which is a great opportunity for you to be able to resolve this case without the necessity of formal probation or anything like that. It's a good opportunity for you that your lawyer was able to garner from the state. So pick up the phone, make sure, and then follow the directions from the probation officer, from Ms. Benavides. We'll take it from there. You won't have to come to court. You won't have to come to court again. And unless, of course, you don't successfully complete the program, but it's not a huge conditional from you, so it should be okay.
Yeah.
Please submit the motion to dismiss, Mr. Garza.
Yes, Your Honor.
Oh, you had another one.
Thank you, Mr. Garza. And Judge, I do have one in the civil docket, cause.
Mr. Sanchez, you're excused for now. Just make sure and pick up Monica Benavides' phone call.
Okay, thank you.
Ms. Anderson.
It's in cause number 7134. I represent Victor Molina.
Yes.
And this case, Flor Flores advised me on Friday that she wouldn't be able to log on today, so she wanted a reset. I agreed to it, Judge. So if whatever the judge has the soonest available, just because we've been.
September the 15th at 1:30.
Okay, that'll work.
And just for the court's record, Elaine Burgess with the Office of the Attorney General.
Okay, Ms. Burgess, thank you. So September the 15th at 1:30, send notice, Noemi, to Ms. Flores, please.
Yes, Judge.
Your Honor, I have an announcement for, on an afternoon docket case. Can I do that?
Go ahead.
It's number 11374. It's a divorce. I represent Erica Olivares. And Miss Minerva Garza represents Mr. Olivares. I don't know if she logged on earlier. I know
Yeah, the court date that we have for this.
Hold on a second. Can you mute Mr. Dankhouse, please? Okay, go ahead.
Your Honor, in this case, Miss Garza has a CPS trial afternoon, so she did ask if we could get a short reset, if possibly even like on the Laredo docket. I
can give you that same September 15th at 1:30.
Okay, we'll work with that, Judge.
So send notice to Ms. Garza on that and notify your clients, please.
Yes, we will. Thank you, Judge.
Thank you.
And I believe all I have. May I be excused?
Yes, good to see you.
Thank you. You all take care. Thanks.
Mr. Villarreal? Calixto Villarreal.
Morning. I have three matters on your docket this morning, Judge.
Yes, sir. You have a Jose Santos Martinez.
Correct, Judge. I got a call from Mr. Garza that he was going to file a continuance. I advised him we were on opposed to it.
That's correct, Your Honor. That's motion for continuance for October 22nd.
Okay, October 22nd then at 9 a.m., sir.
Thank you. My client is logged in, sir.
Mr. Jose Santos Mata.
Yes, sir. Yes, sir.
October 22nd at 9. Stay in touch with your lawyer.
Okay, thank you. Can I have excuse?
Yes, sir, you're excused. Mr. Calixto Villarreal, the other one?
2669, Jose Alejandro Garcia. He should be logged in also, Judge.
Jose Alejandro Garcia, are you present at the hearing?
Yes, sir.
Thank you. This is an evidence exchange. Anything to announce?
Judge, we got the evidence already on this matter. I just want to let the court know that there might have been a capias for him last setting. He was in federal custody. We did announce that. I think there was a capias, but the federal charge was dismissed, Judge.
Can you check, Irene, or I'm sorry, Elba, who's there? Was there a capias issued on?
No, Judge, no capias.
All right, we're good.
Okay, so we do have the evidence already, Judge. We have a complete file on discovery.
Okay, so then you want to go ahead and try and see if you can resolve it by October 22nd?
Yes, Judge.
Stay in touch with your lawyer, Mr. Garcia. October 22nd at 9 is your next court setting.
Your Honor.
Thank you, sir.
Dismissed.
Yes, sir. Mr. Villarreal, that's it?
I have it's a civil matter, Judge. It's an expunction. I got a notice that it was set for 10 o'clock this morning. We're ready. Here in my office. And I believe it's file number 1142. I apologize.
Ex parte Nelson Villa Galvan,
Correct, Judge.
are you there?
He is here in my office, Judge. He's under Calixto Villarreal client.
Just have him say something so we can.
Oh, they're going to go on mute him, Judge. Nelson, can you wave your hand or say hello?
Okay, he's there. Sir, please raise your right hand and be sworn. Raise your right hand and be sworn, sir. You swear testimony you're about to give here in this hearing will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. All right, please take a look at from the clerk's office. Can you check to see if the file is complete with all the notices sent out and everybody received acknowledgements?
Yes, Judge.
Is there a waiver on file, Mr. Atza?
Oh, yeah.
No waiver.
Okay. What is the statute? When does that offense, did this offense occur?
2013, Your Honor. The statute has run.
All right, then no need for a waiver. Any objections to the request, Mr. Garza?
Oh, yeah.
Very well. Court date judicial notice of the entire file. The fact that all the entities that were served received notice that none of them had filed an answer. No one objects to your request, Mr. Villa Galvan. And is that it, Mr. Villarreal?
That's it, Judge. We're asking the court grant or I'll file an order. It has not been.
Mr. Villa Galvan, are all the matters that are set out in your petition true and correct, sir?
Sure.
Are you seeking this expungement because you are entitled to it under the law? Sir?
Yes.
I'm sorry, Judge. It is a verified petition. I should have followed up.
Thank you. Very well. Your petition for the request for petition for expungement is granted. Did you have an order attached to it?
We'll submit that order, Judge, right now.
Okay, I need it by September 15th at 1:30.
Yes, Your Honor.
Thank you.
That's all I have. May I be excused, Judge, till 1:30?
Fernando Sanchez. Yes, sir, Mr. Vera. Thank you. Good to see you. Fernando Sanchez.
Good morning, Your Honor. How are you?
You're on Rubén Terrazas family docket. How are you, Mr. Sanchez?
Pretty good, Judge. How you doing? Nice to see you. Nice to see you too, Mr. Garza.
That's it. Must be. Not a bad attitude for a Monday morning. Pretty good.
Looking forward to this weekend, Judge. Kickoff. Finally. And dove season.
All right.
It's a favorite time of the year.
That's right.
Okay, let's see how things go with you here in court today. We'll see.
All right. Judge, we're set for temporary orders. Just by way of a little background so the court can have.
Wait, I don't want background. I have a big docket here. Hold on, give me a second. All right, do you need a hearing?
Not really, Judge. It's just to prove up.
Have you served
Yes.
with the precept as well?
Yes, it was by publication on July the 8th.
And are they present in the hearing?
My client is the petitioner, Mr. Terrazas is present. I don't think.
Who is the respondent?
Her name is Cruz Gabriela Ramirez Pacheco.
Can you check for service, Elba, or
There's service, Judge, but we don't have the affidavit yet from the Zapata County News.
the return?
Yes, Judge.
When
Believe
is-
we-
Go ahead.
We did e-file everything, I believe. Look through the file.
Judge, it's filed all together. It's there.
Okay, good.
There we go.
Okay, Mr. Sanchez, give me a second. I'm gonna give you like a 10-minute hearing on this then, or what?
Not even, Judge, 5 minutes.
Okay, let's do it right now. Ruben Terrazas.
Yes, Your Honor, I'm present.
All right, let me get you so we can see you here.
He can't be spotlighted because he's just on the phone.
Oh, okay. Ruben Terrazas is only on the phone. Go ahead, sir.
Your Honor, the only thing we're asking here is for status quo on the property. By way of background, there's a protective order out of Hidalgo County. That's where the property is located. It's the party's residence. I did file a motion to transfer the protective order to Zapata. We're still waiting on that. The protective order already gives exclusive temporary use to the respondent and participation of the children by my client. However, the respondent, we believe, has been deported and is no longer in the United States. She probably is in Mexico. She may be here. And as far as temporary orders go, Judge, we're just asking that the property not be encumbered, mortgaged, sold, transferred, or anything of that nature. Once the motion to transfer the protective order is hopefully granted, set in Zapata, then we'll be asking for relief regarding the children and child support and conservatorship and that sort of thing.
So the protective order is against your client?
That is correct, sir. We did file under Exhibit B to this petition.
So today you want what?
We want a temporary restraining order encumbering both parties, especially the respondent, from selling, encumbering, or mortgaging or disposing of any property, specifically the residence located in Donna, 2430 Carnation Drive.
All right. We can do that for now. That's granted. And then you will get the regular hearing on the other matter.
Yes, and we can just have a TOM, Judge. I don't have a date yet.
We have October 22nd.
Okay. Let me work on get that protective order transferred to Zapata, Judge. Hopefully we'll have it by then.
All right, sir. Thank you.
That's all I have, Your Honor. May I be excused?
Yes, sir. Make sure, do we have the judge, or did you submit the order or the judgment?
No, I need to prepare it.
All right, thank you.
Thank you.
Juan Flores?
Good morning, Judge.
Good morning, sir.
Judge, I have 3 cases on the docket, I believe. One of them have already been resolved. Genaro Gerardo Garcia was an agreed 17-151 writ.
Okay.
I sent the order early last week and then again later in the week to.
Yeah, I don't think it's on. Genaro Garcia on 11-460. Poncho, did I already sign off on that order?
It's already signed, Judge.
Yeah, it's already signed, Your Honor.
All right, thank you. Next one, Mr. Flores.
Judge Brian Olivares, I don't believe he's present, Judge.
Brian Olivares.
It's me, sir. It's Rolando Brian Olivares.
Oh, Rolando Brian Olivares. He's present. 2660, status conference. Mr. Flores, do you have his number, Mr. Flores?
Judge, I spoke to him once, and then he had called me or sent me a text about reviewing the evidence. And I responded to him to call me to set up an appointment, but I wasn't able to contact him. He didn't respond when I reached out to him.
Mr. Olivares,
I was in Zapata on last week. I forget what date, and I sent him a text that I was going to be there. I had to go see another person in the jail, but again, I didn't get a response from him.
Mr. Olivares, what's your phone number?
It's 956-206-5716.
Right now, you have to answer your phone calls for your lawyer because it's very important that you find out exactly what's going on and stay on top of your particular circumstances. So you always need to answer your phone, sir. Mr. Did you get that number, Mr. Flores?
No, Judge, the numbers I have are different. Can you repeat it again?
What was it, Mr. Olivares?
It was 956-206-5716.
Anytime you change your number, you need to give that to your lawyer, sir.
Okay.
All right, so I'm going to set you for October 22nd at 9.
Okay, sir.
Mr. Flores.
Yes, Judge, I've got it at 9 a.m. October 22nd.
Very good.
Am I dismissed?
Yes, sir. Make sure you
thank you. I will.
Your next one is, that was it. Luis Rivas.
No, I got one more, Judge. Luis Alberto Rivas, he has two cases.
He's in custody, right?
He's in custody. He's at Zapata. Jail.
Is the jail there? The jail on?
Yes.
Mr. Martinez? Anybody there at the jail? Why don't I see the jail on? They were earlier. Does anybody see them?
No, they're not on anymore.
Poncho, call them.
Yes, sir.
Mr. Flores, just give me a second, okay?
There they are.
No problem.
Wait. Yeah. Did you see them?
They're spotlighted.
Oh, they're spotlighted. Here we go. I got them, Poncho.
Okay.
Mr. Martinez. We are
Yes,
calling
Your Honor.
Luis Rivas. You have him there?
Yes, Your Honor, let me bring him.
You have him on two cases, Mr. Flores, 2662 and 2670.
Yes, Judge, we've been trying to negotiate with Mr. Garza. He did extend a new offer over the weekend, Judge, that I've not had a chance to relay the new offer to Mr. Rivas. But that offer, hopefully, I did respond to Mr. Garza. I haven't heard back from him again, but between his offer and mine, I think we can work something out. I just need some time to go over the new offer with him and then go from there, Judge, as far as the resolution of the two cases. And actually a third case that's not on the docket.
Mr. Rivas, are you there?
Yes, Your Honor.
All right, Mr. Flores, just give an announcement, sir, that Mr. Flores, go ahead and in case Mr. Rivas didn't hear you.
Yes, Judge. Mr. Garza had made a previous offer and I had reviewed all that and the evidence with Mr. Rivas last week. Since then, they made me a new offer that I've not been able to convey with him. And so we need a bit of time for that, Judge. There's also, I had filed last week also on this particular case. He's been in custody for about 8 months. A little, well, yeah, a little over 8 months, I think. It was not indicted within the 90 days. It was indicted, I think, like the 94th day. So we filed a motion for a 17151 release, Judge. He's been in custody this whole time. So that's one consideration, but we do have a new offer that is a global offer, but I do need some time to review that with him. And obviously it's not as easy since he's in Zapata, but I can follow you.
We'll be there Wednesday morning, Mr. Flores.
Right. Yeah, that's what I was gonna say. I'm gonna be there Wednesday, so I'll have an opportunity, I guess, after our hearing on Wednesday to see him at that time, Judge.
All right.
But the reason, Judge, part of the reason for the motion for the bond, the 17151 bond, which I believe he's entitled to under the circumstances.
So what case is that on both of these?
The robbery.
Sorry? On the robbery, Judge. The other case, he's on bond on the other case.
Oh, the conspiracy to commit robbery on that one.
Right. And it's not, I don't know why they have it listed as conspiracy. It's just simply a robbery, but they have it on the docket as a conspiracy. The burglary, he'd been out on bond before.
So on that case, you're saying he should be released as a result of the 17151 situation that occurred prior to indictment.
Right, Judge, on the robbery case. And on the burglary, he was already on bond.
On the 2670. All right.
Right.
So very well, then if that's the case, then we'll have to place him on a PR bond as a result of that, Mr. Garza. You're not disputing any of the allegations made by Mr.
I'm not disputing the 94 days, Judge. I counted them myself. That is correct. I will ask the court to take into consideration that the pending case was a burglary of a building. Subsequent, while out on that case, aggravates it and now goes and commits a robbery. And so there is no evidence or testimony as far as to what Mr. Rivas can afford.
Well,
Well, Judge, actually there is, in the fact that he's indigent, he's in jail, and he has appointed counsel.
Well, you'll have to. Did we lose him already? We lost the Joe?
Yes, the Joe dropped off.
No,
No, they're there at the bottom. I see them.
Oh, okay, there we go. Okay. All right. Please raise your right hand and be sworn, Mr. Diaz. You swear testimony about to give here in this trial will be, in this hearing will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Very good. With regard to, you can put your hand down now. With regard to financial means.
Well, I do have a.
No, your lawyer will ask you a question.
Okay.
Mr. Rivas, how long have you been in jail?
About approximately 8 months.
And during this time, have you been able to work and earn any money?
No, not currently, but I do have a job lined up for me.
Okay. But do you have any funds right now yourself to post for a bond?
No.
Wait for the question to end before you answer, Mr. Rivas, okay? Mr. Rivas, okay?
Okay, yes.
Do you personally own any real estate?
No.
Do you own any stocks or bonds?
No.
Do you have any savings?
No.
I'll pass the witness, Judge.
Anything on the financial?
Mr. Rivas, do you or your wife own a vehicle?
No, not currently.
Okay. Have you contacted any bondsmen about trying to make your bond?
No, sir.
Okay. Do you have any family in Mexico?
No. My dad, but I haven't had contact with him in a long time, so.
Do you guys own your own home?
No, I don't own my own home.
Did you have a checking or a savings account?
No.
Does your wife?
I believe so.
Okay. How about your parents?
I don't know. My mom, I don't know.
Is it possible that your parents could help you?
No. To bond me out, no.
Object to the relevance of that question, Judge?
Sustained.
Do you have anything that you could sell, Mr. Rivas, valuable?
No, I don't.
Is there someone who can lend you the money?
No.
Again, Judge, relevance.
Okay, I'll pass the witness, Your Honor.
Anything else?
Nothing further, Judge.
Very well. The state is stipulated to the fact that the defendant had been in custody for 94 days prior to the indictment, consistently, or what do you call it?
Continuously.
Continuously for 94 days prior to the indictment. The defendant has shown that he does not have any, by way of his testimony, that he does not have any other means to be able to secure a bond. The court has no other, regardless of what the type of offense it was or what came back afterwards. I know you mentioned that it's a subsequent offense that he is being held on. The statute gives us no discretion with regard to that. It doesn't speak to that. It gives no discretion on that. Basically tells us you have to release him. I think what they're thinking, the legislature was thinking, and that, well, I won't make a comment on that. What the legislature was probably thinking is that the DA's office and the police department would know that it was a subsequent offense, and therefore hurry up and prepare the report and get it to the DA's office so that they could get this thing done. In any event, Mr. Rivas is now entitled to a PR bond as a result of all the circumstances.
Maybe the statute doesn't, but the case law does. And I'm citing ex parte plum. Says the ability or the inability of an accused to make bail does not alone control in determining the amount of bail. The nature of the offense or the offenses and the circumstances in which they were committed are also to be considered. And that's ex parte plum 595 Southwest 2nd. So it is something that the court could consider.
I didn't hear any of what you said about the plum.
Just about the nature of the offense and the circumstances surrounding it, Judge, are things that you can consider.
I don't think that's case law that belongs in the. Is it the fourth court?
It is. It's not 17151, but it is 1715 case law, Judge.
But it's not 17151 case law.
No, it's 1715.
And it's not the fourth court, is it?
It's the Court of Criminal Appeals, actually, Judge.
Court of Criminal Appeals on 1715.
Yes, sir.
And that case came. When did that case come out?
That is from 1980, Judge.
Well, again, there's been plenty of case law subsequent to that has basically told us that we don't have any options. I really don't want to. If it's a 1980 case, I don't really have to worry about that because the Court of Criminal Appeals has already heard cases after that have not raised that to contest 17150. In fact, 17151 was created after 1715 and after that case law came into being.
That's fine.
I will do this though. I put them in a strict conditions. Mr. Rivas, we'll release you in a PR bond, but with strict conditions, sir. You will have to be at your home by 8:30 p.m. And you cannot leave your home before 6:30 a.m. Where would you reside, sir?
I could be staying at my fiance's house.
You need to give me an address, sir.
It is 2502 Carlos Street.
All right, that's the address where I'm gonna have. Anything that changes, you need to report it to the court and the clerk. And so it's 8:30 p.m., 6:30 a.m. conditions. You cannot obviously.
Your Honor, it is apartment B as well.
Thank you. You cannot commit any other offenses against this state or any other state. You cannot do any drugs, illegal drugs, in illegal controlled substances. You cannot leave the state of Texas without permission of this court. Do you understand all those conditions, sir?
Yes, Your Honor.
Very good. Then that'll be the order of this court. Your court date is set for October 22nd on both of these cases at 9 a.m. Thank you, sir. All right, Mr. Flores, thank you.
Is that it, Your Honor?
October 22nd at 9 a.m., sir. Don't forget that date. Thank you. Send the disposition into the jail, please, Elba and Irene.
Yes, Judge.
Thank you. Rene Cantu, is it? No. 2685.
Good morning.
Good
morning, Your Honor.
Christopher Cantu, you are here. You are a defendant on cause number 2685. This is your first hearing. Do you have a lawyer, sir?
No, I do not, Your Honor.
Do you understand that you're entitled to have a lawyer represent you throughout this process, and you can hire your own lawyer. If you find that you cannot afford one, you could apply for the services of a lawyer to be assigned a lawyer by the court. Do you understand that, sir?
Yes, sir.
Do you want a lawyer to represent you?
Yes, sir. Yes, Your Honor.
Do you have the ability to hire your own lawyer?
No, sir.
Do you work?
No, I do not. I go to school.
Go to school. Okay. Very well. Poncho, we appoint Mr. Cantu a lawyer and we can set him up for October 22nd, just from the list.
I will, sir.
Mr. Cantu, you're going to be appointed a lawyer.
Yes, Your Honor.
Can we, Poncho,
Can we have his number?
a phone number where they can reach you, sir?
956-202-7986.
An email, sir.
ChristopherCantu@gmail.com.
Got it.
ChristopherCantu@gmail.com and with a phone number.
All right.
You need to come, they will forward that information to the lawyer that we are appointed to, and they'll get a hold of you. So make sure you answer your phone and be back in court on October 22nd at 9 a.m. sir.
Yes, Your Honor.
Thank you.
My excuse, sir?
Yes, sir.
Thank you.
Thank you.
Judge Juan Garcia, Judge.
Mr. I don't know why you don't get on the chat, Mr. Dankhouse. It's very difficult to do, to get to you before that. We have Mr. Dankhouse, go ahead.
Yes, Your Honor. I have Juan Garcia, first person on the docket. And I've been here all morning with you, Judge.
I know, but you need to get on the chat because otherwise I can't see you because I'm not looking at the pictures. I'm looking at the chat.
Oh, I didn't know that.
That's the way I'm calling these cases. Because if you look down here on your screen, see on the screen it says chat.
Yeah.
On the bottom. So if you click on that, you're going to see a whole list of people who jotted their names down, so I could call them. Otherwise, I'm not just calling them because I have them on my list. It's like the equivalent of when you get to court and you get in line. That's what that is. I'm sorry for not explaining that to you earlier. Mr. Dankhouse, go ahead.
Yes, Your Honor. Mr. Garcia should be on.
Juan Carlos Garcia.
Earlier.
Juan Carlos Garcia, are you present? Juan Carlos Garcia.
He's down as Juan Garcia, I believe, down at the bottom of the screen. I spoke to him last time, and I also spoke to Monica briefly about him. He owes money, what he owes. He was supposed to pay her some more money this morning, I believe.
Ms. Benavides.
Yes, Your Honor. His balance on his restitution is $775.80. He's supposed to bring in $250 today, but he doesn't have a ride. So I gave him the address to mail in the money order because he lives in Falcon, Texas.
Do you see him on? Did you see him on earlier?
He's just on the phone under Juan Garcia.
Oh, he is? Because I can't see that.
It shows it to the phone, Your Honor.
Give me a second. Let me see. Why is it? Do I have several screens? No, I just have one. Juan Garcia, are you there? Unmute yourself with a *6*6.
Yes, I'm here.
There you go. Okay. So you're going to mail that in, sir?
Sí, estoy tratando de conseguir who can take me to the mail so I can mail the money order.
Yeah. Okay, well, how long are we gonna give this case, Ms. Benavides? Is that all you really are trying to do on this case? Collect as much as you can on restitution?
Yes, Judge.
We've had it in for a while.
Yes, because he had absconded.
Okay. All right.
October 22nd, Judge. Can we get one more date, Judge?
Second at 9, Mr. Garcia, send that money in. If you don't send that money in, I'm gonna know you're lying to me. I don't want you lying to me, okay?
No, I'm trying to find somebody to take me to the mail so I can mail the money order.
Where do you live?
In Falcon, Texas.
Poncho, they don't have
The mail is in Lopeño.
in Lopeño.
The post office, yes, sir. It's like 5 miles away.
But isn't there somebody that collects mail there in
Falcon?
in Falcon?
No, Yon. The mail, the post office in Lopeño.
There's not like a drop box or anything like that there?
No.
Pues que tienen.
I have to go to Lopeño.
Well, you're gonna have to get a ride and get over there.
Yes, that's what I'm trying to do, to find a ride so they can take me over there.
All right, sir. Thank you.
All I have, Judge, might be excused.
Yes, sir.
I'll
Mr.
get
Dankos,
on chat. I'll get on
next
chat
time, get
next
on
time.
chat.
I
Thank
will,
you.
Your- Thank you, sir.
Let's see. Jose Ramos. You're muted, sir. Jose Luis Ramos.
Right here, Judge.
Yes, sir.
I've got two short announcements, I guess. In my criminal docket, I went this morning to see on 2664, Jamie Lynn Gonzalez. I drove to Zapata this morning.
Jamie Lynn Gonzalez.
Custody.
Jail.
Yes, sir.
Yes, sir. And then the other one is which one, Mr. Ramos?
Arredondo, but he's in quarantine, so the state was in federal custody. The state wasn't able to get him.
Okay.
But on Jamie Lynn, I went to see him this morning in Zapata. Mr. Garza made an offer, but Mr. Gonzalez tells me he's not that guilty, so he didn't accept the offer. So for now, we're setting it for trial. You know, barring if something changes, we
Trial
just
status. That's another one, Poncho. We have three defendants for trial. Let me just get Mr. Gonzalez out. Let me know when he's out. There he is. Mr. Jamie Lynn Gonzalez, is that you, sir?
Yes, sir.
Very good. Mr. Ramos is announcing that he saw you this morning, that he's talked to you about the new offer, and he said that you did not accept it and that you want to go to trial.
Yes, sir.
What was the offer, Mr. Ramos?
it was either 5 years consecutive or 6 years concurrent with a parole violation that he has. He has about 14 months credit to this one because he's been in custody without making this bond. So, you know, I kind of explained that at 25%, it would be one with the other. However, he said no. And so for now, that's where we're at. If he changes his mind, I'll go back and see him later.
What is the minimum amount of time that he's looking at if he goes to trial, Mr. Garza?
On this one, it's 10 years, Judge. The minimum 2, maximum 10. The felony 3s.
Does he have anything else?
The parole.
Yeah, but that's got nothing to do with us here, so.
All right. Well, and you offer him 6, which is 25% would be what? 2, what?
A little less than 2. Yeah. And he's been there for
2, and he's already got 14 months?
Yes, sir. That's what I'm.
Mr. Gonzalez, really? It's a simple.
No. Soy inocente, sir.
All right. If you're innocent, then you roll the dice, sir.
I'm innocent, sir.
We'll give you a trial. It's exactly what you are entitled to, sir, and we will definitely provide that for you.
Well, Mr. Lopez, Your Honor,
Yes, sir.
I wanted to ask you si me pueden dar bond reductions.
I wanted to ask if you can give me a bond reduction.
You have a parole hold, sir. You're not going to get out on a bond because the parole is not letting you out either. So even if I give you bond, it's not going to. It's not going to do.
Pero si I qualify, right?
Well, I mean, you're entitled to bond, but since you have a parole hold and does he have two cases, Mr. Garza?
It's a 2-count indictment.
Ah, okay. I mean, they're only evading arrest, but they're felony 3s, right?
Yes, and a possession felony 3 as well.
All right. It just doesn't,
It doesn't make sense.
it's an evading arrest, like.
Judge, I made the trip this morning to see him, to sign him up, to explain it. That's all that I can do.
All right.
I go to trial. I'm real brave.
He's on a trial track now. October 22nd, I'll tell you exactly when you're gonna go to trial, but you're gonna go to trial. Thank you, Mr. Gonzalez. Okay.
I have a civil case that with Ms. Flores, and she filed a motion. Can we just make the announcement now? The reset?
A civil case in the afternoon?
No, it was at 10 o'clock this morning.
What is it?
199/11103 in the interest of AGJ.
Lord Flores and Jose Luis Ramos in the interest of Alejandra J. Garcia. What's the announcement?
Well, she filed a motion for continuance because she wouldn't be here today.
What's your announcement?
We have no objections to it. We'll just probably come up with an agreed order. I know you asked for an affidavit, but this is not a divorce. It's just a
All right.
custody. So
Katia Ureña, if you're there, and Rene Garcia, if you're here, your case is being passed by your lawyers until October 22nd at 9 a.m. 10 a.m. I'm sorry.
And just for the court's record, Elaine Burgess with the Office of the Attorney General.
Thank you, Ms. Burgess. Thank you, Mr. Ramos.
thank you, Your Honor. May I be excused?
Judge,
So John Arredondo's 1022.
Oh, Arredondo. What did you do with Arredondo?
We just, they just couldn't bring him because he's in quarantine. I don't know. We didn't do anything else.
So we're gonna need another writ on 1022.
Yes, sir.
Another writ for that one. Thank you.
Thank you, Judge.
Thank you, Your Honor. You have a good day, sir.
You too, sir.
Mr.
You guys
Garcia.
you people keep adding stuff to the, I'm gonna knock it off already. On the chat, I mean, supposed to start a little bit earlier.
Good. Yes, Chad.
Melissa Saldaña. Okay, wait a minute, before I start with that. Freddie, or who's at the jail? Mr. Martinez?
Yes, Your Honor.
We need to call in those two, the one at a time, those writs that we have for David Mendez, and then the other one for Alanis.
Okay, which one you want first, Your Honor? Alanis or Mendez?
Well, who got on first? I think it was Mendez who got on first.
Mendez? Okay, they're gonna get him.
Mr. Solis, I know that you signed all the tax documents and you also have an adverse possession at 1:30. Mr. Jimmy Gonzalez, on Ricardo Solis's ad litem appointment, he's already signed off on your cases, right?
Yeah, that's.
Say it again, Judge?
Ricardo Solis, lawyer, he was appointed on some tax cases. He said he signed off on them already.
That is correct, Judge.
Okay, so Mr. Solis, we're good to go. We'll see you on 1:30 for your adverse possession case.
Yes, sir. Thank you. May I be excused?
Yes, we'll see you then.
Good to see you, Judge.
Good to see you too. Ms. Saldaña, we'll be right with you, but I have these other folks that were here before. They've already gotten on the chat 2 or 3 times to remind me of that. Flores, we already made the announcement on with Jose Luis Ramos, so we're good to go on that. Ms. Sanchez, on behalf of Simone and Maria Sanchez, we're gonna call those cases out in a minute. Tell me when the jail's available, Mr. Martinez, okay? All right, so,
Yes, Your Honor.
Judge, I'm sorry.
yes.
There was a defendant on, and I know he was in our Webb County on Friday, Jose Salinas. And I was trying to chat with him to see if he has a case here also, because I don't see his name on the docket, but he's been here the whole time. Jose Alberto Salinas Jr.
Jose Salinas, are you there?
Yes, Your Honor. Yes.
What case do you have, sir?
Pues tenía uno de evading arrest, pero me dijeron que.
Well,
Pero
I had
Zapata
one.
no tengo.
Oh, no, okay. So we need to, you were in court last week, weren't you?
Yes, sir.
And what date did I give you?
October 1st, no. Pero no sé si es con Mr. Nieto.
October 1st, but I don't know if it's with Mr. Nieto.
Well, I don't have another case for you here, so make sure you go to the case that I gave you for that case last Friday. So I don't know,
Okay.
do you have another court for somebody else?
Pues,
Call your lawyer.
según que con Nieto era en este día.
I don't know who Nieto is. You know who your lawyer is? Who's your lawyer?
Pues Mr. Nieto, the public defender.
Oh, public defender. I think you better call the public defender's office. You got into the wrong channel. Okay? Call the public defender.
Okay.
Thank you.
I'm dismissed.
Yes, sir.
Thanks.
Who's this person?
Háblale, Nieto, si no te.
Gladys Isabel Salinas, who are you? What are you waiting for, ma'am? Gladys Bell Salinas.
The tax suit, Judge.
Oh,
Yes, it's a tax property, Judge. I don't know if it's already gone through.
Here we
Oh, you
go.
got my-
Give me 1 second. Give me one
Yes, sir.
second. Let's see. We're calling Mr. Jimmy Gonzalez on your cases. Which ones are you calling, sir? Which ones are you resetting?
None of them, Your Honor. I'm ready to go forward on all of them unless there is a taxpayer present.
All right, here we go. I'm gonna call the cases out. Somebody who these cases belong to, you let me know if you're here for that case. We're here on a case for the taxing entities versus Erlinda Ramirez, deceased. Anybody here on that case? We're also calling on 10509, the taxing entities for Gloria Alicia Flores.
That case was non-suited, Your Honor. I apologize.
Non-suit on that case. 10558, the taxing entities versus Juan Sanchez Quiroga. Anybody on that case? Mr. Richard Gonzalez signed off on the ad litem on that?
He did, he did not, Your Honor.
This was the case in which some folks were found or something like that, was it?
I don't think so, Your Honor, but I submitted I submitted the judgment and the statement of evidence to.
Okay, thank you.
Gonzalez.
I appreciate that, Mr. Gonzalez. Appreciate your work on this case. That's also ready for judgment. Is that correct, Mr. Gonzalez?
Yes, Your Honor.
Okay. The taxing entities versus Maria Juana Martinez. Anybody here on that case? None. The taxing entities versus Mario Garza or Mario Alberto Martinez Jr., Mario Garza Jr. Anybody in that case? The taxing entities versus Clarence Walls, deceased.
Excuse me, Your Honor, that's my case. I was not able to find anybody on that. Of the 3 cases that I have, Your Honor, including the one where the daughter made an appearance, that was Elida Lopez. That case is underwater, Your Honor, meaning that they owe more than what the property is worth. But she said that she wanted to make an appearance And so I made the effort to find the heirs. On Clarence Walls, Your Honor, is the only case out of the three that is above water. And I haven't had a chance to go to Zapata. I don't know if the court wants to give me a chance on that one, Your Honor.
No, as long as you made a very diligent effort to find people, Mr. Jones, that's all I need. You don't need to do anything above and beyond that.
All right, well, then I will submit the paperwork a little bit later on this morning, Your Honor.
Thank you.
I have it ready. I just need to put digital signatures on there.
Very good. And in lieu of that, I mean, as a result of the announcement, I'll sign off on the judgment on that. Zapata County versus Gladysabel Salinas, Gladysbel Rodriguez Salinas.
Yes, Your Honor.
She is present on this case.
On 755, Mario Alberto Martinez Jr. is present, Judge.
Why don't people speak up when I'm asking for them to speak up? I don't understand why is it that you don't speak up, sir. We have a lot of cases, so it'd be really nice if you, when I say your name, that you say I'm here.
I didn't know it was muted, sir. I apologize for that, sir. Good morning, Judge.
Good morning, Mr. Garza. What's your announcement, Mr. Garza?
No, sir, but I don't know if I had some more payments for this coming.
This is the one that you announced last time that you were trying to make payments. That is it's a rental property that you have, right?
Yes, sir. Yes, sir. This month I given a payment for $530 on this month.
Mr. Jimmy Gonzalez.
I mean, Your Honor, there was a payment done. It's what we always talk about this case, Your Honor, substantial amounts owed. So it's basically at a point where it's going to be on your docket for a good amount of time.
What is the amount that he owes on this?
On this case, Judge, he owes there's several accounts, Your Honor. One he owes it's not a total amount for you right now, Judge, I can give you, but it's substantial
guys,
amount of money.
I'm sorry, but Mr. Garza, Mr. Gonzalez, you're all gonna have to be back this afternoon so I can discuss this case.
Yes,
Mario
Judge.
Martinez and Mario Garza, 10-7-55. Come back at 2 o'clock, Mr. Garza.
2 o'clock, sir.
2 p.m. the same way you did right now. Miss Salinas,
Okay, sir, thank you.
10-8-70. Miss Salinas.
Maybe
Yes,
excuse
sir.
her.
Yes, until 2. Miss Salinas.
Okay.
Yes, Your Honor.
What's your announcement here? What's going on?
Last time that we met, that we had court, we had common ingredients that I was supposed to call Ms. Garcia, the person responsible for the tax office there and the property tax for Zapata County. And we made an arrangement for an 18-month period of a payment of $575 per month. I had submitted my July payment a little bit late because of financial reasons. And I just mailed in my Friday payment, my August payment this Friday. I wasn't able to go to Zapata since I'm already back to work. So I did mail it out on Friday. So it should arrive maybe hopefully Tuesday.
Mr. Solis, I'm gonna set this one for your October 22nd docket at 10 a.m. just to check to see if those payments are being made, and if they are, then we'll if they're not, then you can proceed to foreclosure then.
Yes, Judge.
October 22nd at 9, Ms. Salina. Thank you.
Yes, sir. Thank you so much. You have a great day.
10-960, Zapata, all the entities, Abiel Buruato. All the entities, another case, Lucio Sanchez, 11025. Anybody here for that case? Lucio Sanchez. Another case, Rafael Benavides, all the entities versus Rafael A. Benavides, or anybody attached to that.
Yeah, I'm here. I'm here, Judge.
Rafael Benavides is present. What's going on in this case, Mr. Benavides? Are you paying, or you want to pay? Do you not want to proceed? What do you want?
Yeah, I've been doing some payments. In fact, today I'm gonna make another $1,000 for lower the debt.
Are you on a contract?
He's been making payments, Your Honor. He's been doing good payments the last couple of months. I have no objection. The court will allow it that October 22nd.
Mr. Benavides, we're going to set you for that October 22nd day. Continue making your payments. Hopefully things will get resolved, okay?
Thank you.
Thank you, sir. October 22nd.
Okay, thank you.
Thank you. Yes, sir. Elisa Michelle Reeves, 11033. Anybody on that case? Taxing entities versus Rosaura Herrera or Rosaura Perez. Anybody on that case? The taxing entities on 11148 versus Noel Camarillo. Anybody on that case? The taxing entities versus Simon Sanchez. Anybody on that case? Simon Sanchez. The taxing entities versus Guadalupe Paredes. Are you sure that's correct? The taxing entities versus Biliardo Alanis, 11317?
Yes, Your Honor.
Okay. The taxing entity versus Jose Homero Gonzalez. The taxing entities versus Oscar Sanchez.
On that case, Your Honor, it was non-student on May 6, 2021.
Thank you. On all the rest of them that no one has responded to, have there been, are you moving for default judgment on them?
Yes, Your Honor, asking all evidence be submitted in judgment on all those cases.
Okay, we're gonna bring back is only the one on Mr. Garza for 2 o'clock today, sir.
Yes, Your Honor.
All the rest of them, the default judgments are granted. And we'll see you then. Thank you.
Thank you, Judge. May I be excused?
Yes, sir.
Thank you.
Okay, at the jail, are you there?
Yes, Your Honor.
Matthew Allen.
Yes, Your Honor.
Okay, folks, just so before we get started, I'm gonna try and get to whatever I can by 12:30, and then after that, I'm gonna take a break, whether I get to your case or not. I'm trying really hard to get to this docket. I haven't been able to, I haven't even given people a break. I think maybe we took a 5-10 minute break earlier, but that's about it, or at least I did. I don't know if anybody else was able to do that, but in any event, so if I can get to your case before then, I'll get to it. If not, we're gonna have to set it for this afternoon. Mr. Allen, go ahead.
Good morning, Judge. We're here on a bond reduction motion for David Mendez. The defense has one witness. She is present on Zoom. Jacqueline Isabel Rodriguez.
Yes, I'm here.
Ms. Rodriguez, please raise your right hand. What's the cause number on that writ, Mr. Allen?
11,461.
Okay. Ms. Mendez, please raise your right hand. Do you swear testimony you're about to give here in this hearing will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. You can put your hand down now.
Thank you. Ma'am, can you state your full name?
Jacqueline Isabel Rodriguez.
And how do you know David Mendez?
We've been together like for 7 years since high school.
Okay, and how old are you?
I'm 22.
And do you know how old Mr. Mendez is?
He's 25.
Do you currently live together?
Yes.
And how long have you been living together?
5 years.
Where do you live?
1101 Guerrero Avenue.
Is that in Zapata?
Yes, Zapata.
And if Mr. Mendez was released, would he continue living in Zapata?
Yes.
And that would be with you?
Yes. And my daughter.
And how old is your daughter?
She's 5 years old.
And at the time Mr. Mendez was arrested, was he working?
Yes.
You know, if he were released, he'd be able to continue the work.
We couldn't hear that.
Sorry. If he were released, would he be able to continue to work?
Yes.
Okay. And as far as David's finances, does he own any property or vehicles?
He does owe a blue Chevy. And right now we're just renting to own.
Okay. And the blue Chevrolet, what kind of car or truck is
It's like what year?
Yeah.
I'm not sure. I think it's 2007.
Do you know more or less how much that vehicle is worth?
No, I don't know.
Okay. And then as far as if he has any savings account or anything, does he have money saved up, or do you guys live month to month?
We actually live month to month.
Okay. And as far as family and friends willing to help, are you here to speak on their behalf today?
Yes.
Okay. And for the family and friends, how much money do you have to put towards a bond for Mr. Lopez?
And between all of us, we got to do 20 to 25.
20 to 25,000?
Thousand. Yes.
And that amount has been difficult to get to?
Yes, we kind of sold everything.
And do you expect any more than that, or is that pretty much it?
No, I think that's pretty much it.
Okay. And as far as if Mr. Mendez was released on bond, would you make sure that he complies with all orders of the court?
Yes, I would. Yes.
Okay. Thank you, Judge. No further questions.
Any questions of Ms. Rodriguez, Mr. Garza?
Yes, Judge. On that Chevy that you guys own, have you tried selling it?
It's not working.
Okay. Do you know if he has a passport?
Yes, he does.
Does he have family in Mexico?
No.
Has he been in Mexico recently?
No.
Have you talked to his parents to see if they can come up with more money?
No, but I don't really talk to them. It's
Have you contacted any bondsmen to
yes.
help you?
Yes.
How many have you contacted?
Probably 2 or 3.
Okay. Are you working? I don't remember.
Currently, I'm trying to apply for jobs. I'm also trying to get my license. Since it's
Okay. Okay. I'll pass the witness.
Anything else, Mr. Allen?
No, Your Honor.
All right, thank you, Mr. Rodriguez.
And we don't have any further witnesses, just brief argument when the court is ready.
Very well. Anybody else, Mr. Garza, that you want to put on?
We do, Judge. We have Mr. EJ Salinas, who I believe is on. He's muted.
Hello, can you hear me?
And it seems like Mr. Allen has just been really arguing I think he's about to argue the amount of the bond. I don't think he really, I mean, even though it's a writ, in other words, it could be a writ because the bond is too high, or it could be a writ because you're holding them illegally because there was no offense. In this case, I think he's just arguing bond is too high, or about to argue bond is too high.
Yes, sir. It's just that the nature of the offense and the circumstances and the punishment that could be assessed is something that the court can consider.
Go ahead, Mr. Salinas.
I think Mr. Salinas needs to be sworn in, Judge.
You swear Mr. Salinas. You swear testimony you're about to give here in this hearing be the truth, the whole truth, nothing but the truth, so help you God?
I do, Judge.
Thank you.
Will you state your name, please?
Ernesto Javier Salinas, but I go by EJ.
And Mr. Salinas, how are you employed, sir?
I work for the Texas Department of Public Safety as a Texas Ranger.
Okay. Are you personally familiar with this defendant, Mr. Mendez?
Yes.
Okay. And how is it that you became familiar with him?
Through the murder investigation of Mr. Santos Flores III.
Okay. So were you the one that applied for a warrant for the murder case, the murder charge?
Yes.
Okay. Specifically, what facts did you have when you applied for that warrant as far as probable cause on Mr. Mendez?
Mr. Mendez was originally detained by the sheriff's office for, I guess, possession of marijuana. During the course of the investigation, we were able to extract information from his cell phone. And once confronted with the cellular phone extraction information, he basically confessed to his involvement about the murder.
Okay. Specifically, when you said he confessed, give us some of the details of what of the admissions he made.
He admitted that he was, I guess, called into Mexico to meet with the drug cartels. He refers to Mr. Santos Flores. He owed some drug money. After that, he was able to arrange the two hitmen to come into Zapata, and he had them at some safe houses there in Zapata. We have also a video of him dropping off the hitman, and the GPS cellular phone extraction report confirms his vehicle going into the area and leaving the area.
I'll pass the witness, Your Honor.
Just briefly, Mr. Salinas, the conversation with Mr. Mendez, was that recorded?
Yes, sir.
Okay, has that been provided to the district attorney's office?
At this time, we're still working on the investigation. It's currently a work in progress.
Okay, so your investigation isn't even complete yet, is that right?
No, sir. No.
And obviously, things change in an investigation that changes your opinion of the case?
Correct.
Okay. No further questions, Judge.
So, Mr. Salinas, you've got him on one count of murder. Is that what you arrested him for? Okay.
Yes.
Okay, thank you. No further questions, Your Honor.
Nothing else, Judge.
Give me 1 second, guys.
Yes, sir.
Okay, go ahead, Mr. Mendez. Mr. Allen.
Thank you, Judge. Just briefly, we're here on the bond reduction. I believe the bond is currently set at $1 million. It's charged as a murder case. It's a first-degree felony, anywhere from 5 years to 99 years. As far as aggravating circumstances, it doesn't sound like, as far as Mr. Mendez, that he was on. There was no evidence he was on the run, that he, fought with law enforcement or any of that type of information. He's been living in Zapata. He lives with his girlfriend. He'd be able to live there with the court. As far as his passport, he could surrender the passport as a condition of bond. There's also conditions such as GPS, a curfew, checking in, drug, alcohol tests. It sounds like Mr. Mendez would be able to work again. As far as the amount, his family, it sounds like, has done everything they can to come up with as much as they possibly can. And that's $20,000 to $25,000. So we would ask that the bond be set somewhere where they would be able to make that bond and Mr. Mendez be able to show that he would abide by all those conditions of the court. We don't feel that Mr. Mendez is a flight risk or that he would be a danger with those conditions, and that the amount of bond we would ask to be set at $100,000. That's all from the defense, Your Honor.
Thank you. Mr. Arson.
Judge, as far as the ties to the community, I'm not sure that we have enough evidence. The lady is his girlfriend, and so I would say that he is a flight risk because there aren't that many ties to him there in Zapata. I don't think I have to go over the 1715 rules for fixing bail. I know the court is well aware of them. But now we are talking about a 1715 where the court can consider all the circumstances. The fact of this is in essence, a murder for hire as opposed to a random type. Now you've got a set plan of at least from when Mr. Salinas told us this morning of coming and doing this. And so what we have is in essence what we've tried to avoid, which is the spillover violence from Mexico, which we were pretty successful in deterring all these years in Zapata. And so we've got to treat it a lot different. I don't have to mention that we are on the border. There's obviously ties to Mexico. This case stems from that. And so I would ask that the court take all that into consideration. The punishment that could be assessed this is a felony 1, as Mr. Allen told the court. And the brazen part of the murder was, Judge, a home invasion. And so this is, you talk about aggravating circumstances, we have them all here. And so I would ask that the bail amount remain the same. That's all I have, Judge.
Thank you. All right, I'm the one that set the bond from the very beginning. I obviously not knowing a lot of the circumstances then, fully, who people were, whatnot. I have a little bit more now about them and about the defendant. So I'll take that into account and place the bond at $650,000. Thank you. With obviously that's conditions. They're going to be standard conditions if in case he gets released. It's my standard condition for a case like this is that he would cannot leave the house after 8:30 p.m. Has to be in his home cannot leave after 8:30. Has to be in his house by 8:30 p.m. Cannot leave until 6:30 a.m. Cannot travel outside jurisdiction of this court. Cannot consume any drugs or alcohol or illegal controlled substance or illegal drugs. So in any event, just in case he's able to bond out, that's conditions that he would be under. Do you understand those conditions just in case you're able to bond out, Mr. Mendez?
Sure.
Thank you. Thank you all.
Hey, sir, can I say one? It's because I work oil field, sir. And like we don't have a schedule, like an everyday schedule. Sometimes they call us at night or in the mornings.
Mr. Mendez, we'll talk about that and the conditions, okay?
All right, sounds good. Thank you, sir.
Thank you, Your Honor. May we be excused?
That's it, sir. Thank you.
Judge, can I be excused?
Yes, we have another case.
We still have the co-defendant, Judge.
The other, go ahead and bring the other one out, Mr. Martinez.
Yes, Your Honor.
Yes.
While we wait for that, let's see, there's somebody that says Jessica Lara 2684.
I think that's one of the new cases, Judge.
Judge, I'm back on. I'm at federal court. This is Oscar Vega. I'm sorry for the interruption.
Okay, we're calling your client's coming up. Oscar, I mean, Jessica Lara, are you there?
Yes, I'm here.
Okay, Jessica, you don't have a lawyer right now, is that correct?
No.
Okay, could I have a phone number? We're gonna appoint a lawyer to represent you. Could
Your Honor, I think it's Davalos Garcia.
Okay. Juan Garcia Davalos is your lawyer. Could I have a phone number where he can call you, ma'am?
Yes, 956-265-4048.
Okay, he will be calling at that number, and you need to come back to court on October 22nd at 9 a.m.
Okay, thank you. Am I dismissed?
October 22nd at 9 a.m., ma'am. You will not get any other notice. So make sure you do it the same way you did today. Thank you.
Okay, thank you.
Jose Armando Garza, are you there? Go ahead and bring that the other one out, Mr. Martinez, okay?
Yes, Your Honor.
Thank you. Jose Armando Garza, are you there?
He's not present, Your Honor. He's serving a federal sentence. And Mr. Pete Garza from the DA's office was supposed to make a decision as to whether he was going to proceed or dismiss.
He's got a new indictment, Judge. It's set for consultation.
Right.
For what day?
So we'll obviously look into his federal. Let's see if he's been convicted and let's see what his sentence is.
Okay, so we have a new indictment, Mr. Gonzalez. You'll be appointed on this one too. Jose Armando Garza.
Is that the one that's set for today?
Yes.
Yes. 2675.
2683.
775, Your Honor.
You got two, 2675, 2683.
They're both set.
Yeah.
So you're going to be appointed on both, Mr. Gonzalez. So we're going to set both of them for October 22nd at 9, and Mr. Garza, Mr. Pete Garza will give you his final. Just continue talking to him about that.
Yes, Your Honor. He's in federal custody.
All right.
I sent the paperwork.
Could you send Mr. Garza the information so that he can look into it, sir?
I did, Your Honor.
All right. Thank you, sir.
Thank you, Your Honor.
All right. Back up to jail. We have Alanis.
Are you talking about right, Alanis?
Yes, Your Honor.
What is your name, sir?
Gilardo Alanis, Your Honor.
All right. Your lawyer is on the line. I believe it's Mr. Vega.
Yes, Your Honor.
All right, Mr. Vega, you have a writ, and Mr. You are in a car, but you're not driving. Is that correct?
No, sir, no. I pulled over. I just got out of federal court and I didn't want to wait the 10 minutes to get to the office, Judge.
Okay.
I didn't know what your schedule was. I'm sorry.
Yeah, our schedule is a little bit overwhelming today, but that's fine. So here we are with the writ. Mr. Do you have any witnesses?
Judge, I have a text when I got in the car, said they were disconnected. I do have a witness. It's my client's mom. If I can.
What's her name? What's your mother's name, Mr. Alanis?
My mom's name is Ileana Alanis, Your Honor.
Ileana Alanis, are you there?
Yes, sir.
Oh, there she is.
Ileana Alanis is where?
She's spotlighted, Your Honor.
Oh, she is? I'm sorry. Okay.
Judge, I'm not sure if that person behind her is recording.
That gentleman right there, you cannot be recording any of these proceedings.
Okay.
None of them.
Okay.
Tell him that to put that camera off.
Okay.
Thank you. Okay, so Ms. Alanis, please raise your right hand and be sworn, ma'am. Do you swear testimony you're about to give here in this hearing will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Thank you. Mr. Vega.
Yes, Your Honor. Ms. Alanis, state your full name for the record, please.
My name is Ileana Alanis.
Okay, and the gentleman that you previously saw on the screen, that is your son, Biardo Alanis?
Yes, sir.
Okay, and you understand that he was arrested for I believe, the offense of murder.
Yes, sir.
And the judge gave him a bond of $1 million.
Yes, sir.
Okay. Does Mr. Alanis have $1 million in his bank account?
No, sir.
Do you know how much?
Go ahead.
Do you know how much money he has in his account?
He has $500.
Okay. Does he own any stocks or bonds?
No, sir.
Does he own any real estate?
No, sir.
Okay. As a family, ma'am, do you have a job outside your home?
I do. He doesn't.
Okay. Does your husband?
Yes, he does.
What does your husband do?
My husband has a small business. It's a self-employed paint and body shop.
Okay. And if your son was released on bond, is that where he's going to work?
Yes, sir. My husband had a stroke 1 year ago, so he's gonna put Billy on the business to take over the business.
Okay. As a family, how much money were you able to gather together to post a bond?
$8,000.
Okay. That would make it about an $80,000 bond. Is that correct?
Yes, sir.
Is that what the bondsman would charge you?
Well, I haven't talked to my bondsman yet, but I need to call him to see.
Billy cannot post any bonds, correct?
No.
Okay. Mr. Alanis, I'm sorry. Do you promise to make sure he appears to all court
Yes.
settings?
Yes, sir.
Okay. And you will not allow him to travel to Mexico?
No.
Okay. And that you will ensure that he abides by all state and federal laws?
Yes, sir.
Okay, so you're requesting that the judge reduce the bond from 1 million to 80,000?
Yes, sir.
Judge, that's all we have of this witness.
Mr. Garza.
Ms. Alanis, does your son own a car, a vehicle?
No, sir.
Does he have a passport?
No, sir.
Do you guys have family in Mexico?
No, sir.
Do you know if he's been in Mexico recently?
No, sir.
You don't know or no?
No, he hasn't been in Mexico.
Did you say if you guys own a home?
I do. My home's, I own my home.
Okay. And I think you stated earlier you have not talked to any bondsmen in town?
Yeah, I talked to two, one here, a friend in Zapata and the other one, but it's mostly the one here in Zapata.
Okay. Have you contacted anybody about borrowing any money?
Yes, sir.
And are you going to be, will you be able to?
Yes, sir.
Okay. No further questions, Judge. I'll pass the witness.
Anything else, Mr. Vega?
Judge, if I can, I forgot to ask Ms. Alanis, ma'am, your son is a U.S. citizen
Yes, sir.
and he's lived all his life there in Zapata County?
Yes, sir. We've been living here in the address almost 20 years.
That's all I have, Judge.
All right. Mr. Garza, any witnesses?
Judge, again, Mr. Salinas, the ranger.
Go ahead. Ms. Salinas, please raise your right hand and be sworn. Swear testimony about to give here in the hearing will be the truth, the whole truth, nothing but the truth, so help you God.
I do, Judge.
Thank you. Go ahead.
And say your full name again, sir.
Yes, Ernesto Javier Salinas. I go by EJ.
And how are you employed, sir?
Texas Department of Public Safety as a Texas Ranger.
And how long have you been there with DPS?
Going on 25 years.
Okay. Are you familiar with this defendant?
Yes.
Okay. And this defendant is related to the co-defendant that you just testified in?
Yes.
Okay. Did you arrest Mr. Alanis?
Yes.
And what was the charge?
The same charge as murder.
Okay. Did you allow him to give you statements?
Yes.
And did he in fact give you a statement?
Yes.
Okay. Did any of those, in any of those statements, did he make admissions to you?
Yes.
And specifically, what did he tell you in reference to the murder case?
The same circumstances and facts as his co-defendant, Mr. Mendez stated.
Mr. Nunez, I know you want to reference the other hearing, but we can't reference it. Just, you got to talk about specifically what was done here.
Yes, sir. After we confronted the defendant with some cell phone extraction information, he confessed to his involvement, him and David, and bringing those two hitmen to Zapata to conduct the killing of Mr. Santos.
Okay, so they were in essence involved in smuggling aliens across the border?
Yes.
Okay. Do you know if Mr. Alanis is active on social media or was active on social media?
Yes.
Okay. Did he admit to also, in essence, to picking up those hitmen?
Yes.
Okay. Was he also involved in getting those hitmen out of town, or at least to so that law enforcement could not find them?
Yes.
Okay. I'll pass the witness, Your Honor.
Ranger Salinas, when you said he made admissions, did he actually say, I knew I was bringing hitmen to Zapata?
They call it special, they have a word for it, I can't remember. They say like a special aliens or special people.
Did he acknowledge that did he admit to you that he had prior knowledge that they were going to murder this gentleman?
Not prior knowledge that they were going to murder, no.
Okay. So actually the admissions he made is that he found out later that he had crossed some illegal aliens that happened to have allegedly murdered this gentleman. Is that what the admission was?
Yes, sir.
Okay. That's a lot different than saying, I know I'm going to intentionally bring somebody over to kill someone. You agree with me?
Yes, sir.
And did he admit to you that he knew that they had murdered him and he intentionally took him to another place to escape law enforcement?
That who did, sir?
Is that the exact statement? Or can you please give us the exact statement?
No, that he picked him up to bring him across from Mexico to Zapata.
No, but after the murder, you said that he made admissions that he.
No, after the murder, no. After the murder, no. It was somebody else who picked him up. It was David.
Okay. Just to clarify that. Thank you, Judge. That's all we have with this witness.
More questions for Mr. Salinas, Judge?
Yep.
Mr. Salinas, was Mr. Alanis in the vehicle that the hitmen were in? Like, were they all together?
In the morning, they were.
Okay. Now, did those hitmen, and you saw some videos, did they have long rifles or did they have, like, say, handguns?
The one I saw had a long rifle.
Okay. So obviously you couldn't hide. I mean, they're pretty visible.
Correct.
Okay. Now, in the vehicle that Mr. Alanis was in, were there weapons in that vehicle?
No, in the Mr. Alanis's, no.
Okay. How about in Mr. Mendez's?
Yes, we found a pistol in one of his trucks and some ammo in his house consistent with the murder scene. With Mr. Alanis, there was weapons found, but they were in his, I believe, in his room.
Okay, but Mr. Alanis was in the vehicle with Mr. Mendez?
Yes, correct.
Okay, that's it. No further questions, Judge. I'll pass the witness.
I'm sorry, Ranger, I don't understand. What point in time was he in the vehicle with Mr. Mendez?
The morning of the murder.
The morning, the murder happened at what time?
Early in the morning, about 5 o'clock, early in the morning.
Okay, and when was he seen in the vehicle with Mr. Mendez?
A couple of hours afterwards, some of the deputies were able to identify David's truck, and they went to his house looking for him. He wasn't there, and Mr. Alanis arrived with Mendez in his vehicle, in his truck.
Okay, so you don't, Mr. Alanis was not with Mr. Mendez when he allegedly had individuals that had firearms with him.
We don't know that for a fact. We don't know that. It was through the video surveillance, and it was at nighttime. They only captured one angle of the truck.
Okay, so you don't have anybody placing my client in the vehicle at that time?
That's correct.
Okay, so why is he charged with murder?
Because originally the people that the witness, the female witness, described a heavyset guy with camouflage and a thin person with a defined jawline, which when the deputies reviewed the videos of them arriving at the scene, they saw the vehicle leaving, and one of the deputies recognized him as David's truck. So they went to go looking for them, and that's when they saw them. They fit the description, plus what the confession from David places Alanis also with them involved in collaborating with bringing in these people and hiding them in different stash houses.
The confession of that David said that Mr. Alanis assisted him in committing the murder.
Yes, sir.
He made that statement.
Yes, sir. That he assisted them in moving the two special interest aliens from stash houses to stash houses and picking them up.
Okay, but you're not. I already asked you whether if my client had prior knowledge these individuals were going to murder someone, and you said no, that you don't have that information. So it's different from moving aliens from stash house to stash house and trying to commit a murder. Do you have David, and I don't know his last name, I'm sorry, saying that my client assisted him in committing the murder, not moving aliens to stash houses?
No. David didn't say that Billy committed the murder.
That's all we have, Judge.
No further questions, Your Honor.
All right. Once again, in this case, there was probable cause that when the warrants were issued to find that, in fact, it's more likely than not that they were involved with the evidence that was presented to the court then. It's a very low burden, as you all know. And so at this point, again, when the evidence was presented to the court about who this particular defendant was, what connections he has to Zapata, there's very little of that a court actually had. So the bond was placed high in order to be able to assure ourselves that, in fact, it wasn't somebody that could just easily go and come back and cross and whatnot. So there's more information that I have now, and as a result of that, bond will be lowered, $550,000. With conditions, again, if he happens to bond out, can't leave the house after 8:30. Has to be in the house by 8:30 p.m. Cannot leave before 6:30 a.m. Cannot consume illegal controlled substances. Cannot commit any other violations of the offenses of this state or any other state. Thank you.
Thank you.
Thank you, Judge.
Folks, it is 12:30. Let's see what we have left so that I can tell you what we're going to do. First of all, on the criminal docket, real quick, Octavio Gonzalez, are you here?
He is present, Your Honor.
He is present. What's your announcement there, Mr. Gonzalez?
We're not ready on that one, Your Honor.
We're going to have a hearing finally on this one at some point, and we may have to have it on October 22nd. Be ready for that if you don't reach an agreement.
Yes, Your Honor.
9 o'clock. Mr. Gonzalez, are you there, Octavio?
Sí, señor juez.
Okay, we'll see you on October 22nd at 9 a.m., sir. Stay in touch with your lawyer.
Yes, Your Honor. Entonces su siguiente cita es el 22 de octubre a las 9 de la mañana.
Gracias.
Juan José Navarro. Juan José Navarro.
Your Honor, he's currently at Webb County Jail on another case in Webb County.
We'll get a date for another bench warrant.
Bench warrant with similar language, with virtual language, please.
Yes, sir.
October 22nd at 9. Leobardo Mandujano.
He's in federal custody, also in Laredo.
We're going to get a writ. See if you want to get him bound or not, writ, Mr. Garza, by October 22nd. Also with some alternative virtual language. October 22nd. Francisco Javier Villarreal.
Yes, Your Honor.
He is present in the hearing. Mr. Richard Gonzalez.
We're not ready on that one, Your Honor.
The plea status, you were going to talk to him about potential plea.
Yes, Your Honor. I've just been a little overwhelmed lately.
Yes, sir. I'll give you some time, but it's been on the file for quite some time already.
Yes, Your Honor. He has multiple arrests.
It's going on 2 years. I need an answer by, otherwise I'm going to put it on the trial docket. Give us the plea. I'm going to give you a plea status on October 22nd, 9, and we'll see. We'll take it from. We'll see where we go from there. Thank you.
Your Honor.
Arredondo, what do we do with him? Oh, we're gonna get a writ, right?
You gave us another day, Judge.
Okay. Leroy Alanis.
Judge, he was in attendance at his father's funeral this morning. And we would ask the court to reset the case, Your Honor.
September 15th at 1:30. September 15th at 1:30. He should be calling the court for that, and if he doesn't, then he won't get the date, but he knew he had to be in court today.
I have communication with him, Your Honor.
Thank you, sir.
Thank you, Your Honor. That's all I have for today, Your Honor.
Yes, sir, Mr. Gonzalez, gracias. Russell Wayne Escamilla.
Am I excused?
Who's that?
Francisco Villarreal.
Yes, sir. Russell Wayne Escamilla.
Set for consultation.
Thank you, sir. Russell Wayne Escamilla, can you check for service?
Judge, there's no service, Judge. We mailed it out, but we don't have a return.
I think he lives in Kingsville.
When did y'all mail it out?
We mailed it out on July 16, Judge.
July 16th?
And we mailed it to the bond also, Judge.
All right, I'm good with that. Anything from Mr. Garza?
Capias, no bond, Judge.
Capias will be issued, no bond. Give me 1 second, folks. Oh. Okay, folks, Mr. Castillo,
Yes, Your Honor.
go ahead.
Yes, Your Honor. This was a case that I was wanting to prove up the receivership. I did
Yes.
want to let the court know, however the court wants to proceed with it. I was looking at my file. I did notify Mr. Guevara that I'm lacking one service or requirement, which would be the publication. But if we could prove it up now and allow me to check that box, so to speak, or we could just come back September 5th and 15th and just do everything all at once, Your Honor. But my client is ready to testify.
Mr. Guevara, he's ready now, and I understand that, but we're not gonna be able to do anything until that happens anyways. So
Yes,
why
sir.
not, right now, especially on the docket that I have, Mr. Guevara, we're gonna wait till September 15th because there's that service that's still required on that publication. And you weren't gonna be able to do anything anyways, and it's so easy to get on now, you don't have to travel or get out of your house or whatnot, so let's get you back on at 1:30 on September 15th, sir. To be able to.
Good, Judge.
I appreciate
I'll take care
your
of the
time.
publication in the
Say hi to your
meantime.
dad for me, Mr. Guevara. He looked really good.
He just left, he turned 94 this month.
Yes, we're blessed. My dad's just turned 87 recently, and he remembers your dad fondly. Thank you.
Yes, thank you, Judge.
All right, bye-bye.
I'll take care of the publication and we'll be before Your Honor on the 15th, Judge. Thank
Thank
you.
you, sir. Now, folks, let's see. I thought I saw Marty Dayano. Yes, there you are. What are
I'm
you?
with Miss Maddox, Your Honor. We have a motion for summary judgment.
Is that on this afternoon?
This morning.
This morning.
No, I can't do anything like that this morning because we're done with our morning. Our morning is done. What case it is it?
It's a cause number 11289 in the interest of KMS, but I'm willing to come back this afternoon, Your Honor. That's not a problem.
Yes, I'm unfortunate because I have to let my folks go out for lunch,
I understand.
and I apologize that I'm not gonna be able to squeeze you all in. But let's make it. When do y'all have to leave for the day? Because I know I want to call the docket this afternoon, and then hear you all. The docket this afternoon is just, the civil docket's been going so quickly lately that I expect that's going to happen as well again. Why don't we try and make it come back at 3:00. We should be able to get you all in.
Yes, sir. We'll be back.
Thank you. 3:00.
We'll be back at 3. Thank you, Judge.
Thank
Bye,
you.
Miss Maddox.
Bye. See you soon.
I don't know who else is there that, Ms. Garza, I thought you all had left already. Minerva.
Judge, I was coming and going. I was having audio problems with the other device I was trying to use. But
Okay, Ms. Saldana, what do you have? I know you had gone into the chat.
Yes, Your Honor. I have a couple of cases with Minerva Garza. I have the cause numbers 10471 and 10,532. We're asking for a reset on both cases. We are both available November 1st, 2021.
Ms. Garza.
that's correct, Judge. I emailed Noemi the information and Ms. Saldana and Ms. Burgess on the one that involves the AG. Everybody's in the loop.
And we're here on the
Cause
10th.
numbers, give me those cause numbers again.
Yes, Your Honor. 10,471 and 10,532.
Very well. November 1st, 10 a.m. Thank you.
Thank you, Judge. And Ms. Anderson, Brenda Anderson had already announced on my other case. Ms. Flores, I had 2 cases with Ms. Flores, but she filed Rule 11 agreements. And I had no objection because I have that conflict this afternoon with that.
I already got that.
So that should take care of me, Judge, if I can be excused.
Thank you, ma'am.
Thank you.
See, I have one more attorney there. Who is it? Espinosa, Pilar Espinosa,
Good morning, Judge. If I can make a quick announcement,
your case, sir?
it's 11,305.
Linda Mesa, Robert Bustamante.
Yes, Judge. We have it set for, I represent Linda Mesa. We had it set for temporary restraining order. Mr. Bustamante is pro se. We spoke to him. He said he was in agreement with making the announcement to the court, and I believe they're both present.
Espinosa, I'm sorry, Bustamante, Roberto, and Linda Mesa.
Yes, I'm here, Judge.
Linda's there.
Yes, I'm here.
Roberto's there. Okay. Listen carefully to the announcement. Go ahead, Mr. Espinosa.
Judge, in speaking with Mr. Bustamante, Ms. Mesa, the agreement is the child support will remain as temporary orders, the way Mr. Bustamante is currently paying. Ms. Mesa will have exclusive use of the property known as 527 Flores Drive in Zapata, Texas, and that visitations will be upon mutual agreement. And if that doesn't work, then they will have standard possession visitation for Mr. Bustamante, and Ms. Mesa will be the primary conservator at this time.
Is that your agreement, Mr. Bustamante?
Yes, yes, sir.
Miss Mesa,
Yes.
thank you. Submit the temporary orders, please. And you already have the trial on the merit state, right?
Yes.
It already passed, Judge.
Oh, give me another date then. Do you want to do it on October 22nd or November 1st? Actually, November 1st.
Thank you, Judge.
November 1st at 10 a.m. We'll finalize it then. Thank you.
Nothing further, Judge. Can we be excused?
All three of you can. Thank you.
Thank
Now,
you.
folks, I need to go. I know a bunch of you are still here, but I have to allow my staff and clerk staff and everyone else to go to lunch. I think that we should be able to be back in an hour. It's 12:53, so now it's going to be 2 o'clock by the time we get back. And we'll hear your case at some point today. At some point today, we'll hear your cases. So I guarantee you that. Can you say it in Spanish, Mera, please?
Sí, en este momento tengo que dejar a todos los que están trabajando ahorita para que vayan a un receso y vayan a comer. Bueno, vamos a regresar hasta como después de las 2 de la tarde.
I will get to your cases today, though.
Entonces, pero sí vamos a atender sus casos esta tarde.
All right. See you then.
Nos vemos esta tarde.
Leave it open, everybody.
Thank you, John.
Nomi, are you there? Madab, are you there?
Yes.
Okay. I'm going to go ahead and let everybody in since it's late and let them know what's going on, and then we can identify the people that don't have names. Good afternoon, everybody. Sorry for the delay. We did run late with court this afternoon from the morning. We didn't finish until about 1 o'clock, so the judge is going to be getting on shortly. He said probably about 2 o'clock. I think most of you have been with us before. If you have something that is going to be a quick announcement, please use the chat feature and put your name, your cause number, or if you know the page number or your client's name, something to identify your case. And the judge will call those in the order that they appear in the chat. Once he goes through the chat, then he'll call anybody who's left to see if you're going to require a hearing, and he'll take you in accordance of how long you think your hearing is going to last. We do have a lot of people that from the morning docket that we did not get to, so they have come back. So just hang tight because we do have all these cases that were previously set for the afternoon.
Ma'am, I had a quick question.
Yes, sir.
This is Domingo Reyes.
Okay, let me change your name first. Domingo Reyes. Okay, yes, sir.
Domingo
You were
Reyes,
here this morning?
Yes, ma'am. I didn't get called.
Yes, all the cases that he did not call, he has a note of that. The cases from the morning that he didn't get to.
Okay.
Yes, I see your case.
Okay. So I just wait online.
Yes, sir. Just please wait.
All right. Thank you, ma'am.
Thank you. You can go ahead and mute yourself.
Okay.
Okay, thank you. Okay, there's a gentleman that just says Leroy. Can you unmute yourself and give us your full name, sir?
Hello, Rolando Gonzalez.
Your name is Rolando Gonzalez?
Yes, ma'am.
Okay. Thank you, sir. You can go ahead and mute yourself now. And then there's Irma's tablet. Can you unmute yourself, ma'am? Irma's tablet. Can you unmute yourself?
I'm here, sir.
Yes, ma'am.
There we go. Sorry about that. Okay,
Yes.
what is your name, please?
Irma and Eric Little.
Okay, thank you. You can go ahead and mute yourself now. I changed it. Thank you.
Mr. Mario Garza Martinez, do you
Uh,
mind muting yourself until the judge calls your case, please?
I muted, ma'am.
Yes, can you please mute it?
Okay. Thank you.
Thank you.
Yeah.
The iPhone that's unmuted, what is your name?
Mande.
Sí, su nombre.
Yesenia Canales.
Ok, gracias. Si puede apagar el micrófono hasta que el juez llame su causa.
Sí, está bien.
How's it going, Chris?
Hey, Marcel, how's it going, man?
Good.
All right, folks. Good afternoon. We're running late because we finished our morning docket closer to 1 o'clock, and we have some people coming back that we have to take care of. So if you're not in the chat for agreed announcements or unopposed announcements, please get on it now. And So we're gonna go through this docket with agreed announcements or unopposed announcements as soon as we can. And then we'll come back to do what came in from the morning. And then we'll entertain, if your announcement is we need a hearing, you give me an estimate on your time as well, please. Appreciate that. Thank you. Okay, let's start with the chat.
The first one is at 1:57, Judge, with Sergio Davila.
How you doing, Judge?
Good morning, Mr. Davila.
Just making sure I'm not on mute. Sorry about that.
You're what?
I believe the witness is here.
All right,
This is
cause
on
number 11-432. Can you hear me?
Yes, sir.
All right,
Yes,
let me
sir.
call the case. Let me call the case, please, sir. Cause number 11-432, Mr. Davila, application for approval of sale or partial payment, and your witness or the person who is selling the annuity is who?
Rolando Gonzalez, and I've seen him in the gallery. So
All right.
he should
Rolando
be here.
Gonzalez, are
There he
you
is.
there?
He just needs to
Yes,
unmute.
sir.
Okay, Mr. Gonzalez, please raise your right hand so I can swear you in, sir. You swear testimony you're about to give here in the trial be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Yes or no?
Yes, sir.
Thank you, sir. You can put your hand down now. Mr. Gonzalez, you understand that somebody's trying to buy your annuity, you're trying to sell it. They are represented by an attorney, you are not. You understand that, right?
Yes, sir.
And do you feel comfortable proceeding in that manner?
Yes, sir.
Okay? And you understand that Mr. Davila and the people who he is standing in for represent the interest of the person, the entity who's trying to buy your annuity. You understand that? They don't represent you. Do you understand that?
Yes, sir.
Very well. And knowing that, sir, you still want to proceed this way?
Yes.
Thank you. Mr. Davila.
Great. I want you to, Mr. Gonzalez, if you can state your full name and address for the record.
Rolando Gonzalez.
Feel free to lead the witness, Mr. Davila. We got a full docket today.
Sure. Full name and address. Dirección.
Rolando Gonzalez, P.O. Box 304, San Ignacio, Texas.
And it's true that you're selling $79,002 of that of an annuity to my client, J.G. Wentworth Originations LLC.
Give me a second, because he needs an interpreter. Metal, be there?
Yes.
Present, Your Honor.
Go ahead.
I need interpreter request a repetition.
Yes, it's true that you are selling $79,002 of that annuity to my client, J.G. Wentworth Originations LLC.
Es cierto que usted está vendiendo su contrato en la cantidad de $79,002 a G&G Wentworth.
No, ma'am, I believe that's 35,000.
No, I believe it's 35,000.
My question was that you are selling $79,000.
Give me 1 second. Mr. Avila, give me a second. Mr. Gonzalez.
Mande, sir.
They're not talking about what you're going to receive, but that the contract is if the payout is done over the course of time, you would be receiving that amount. But if you get it now, it's only going to be 35. You understand that?
Right.
Okay.
Yes, sir.
But the contract is not for the contract that you have is not for 35. The contract that you have is you're selling one for 79.
Yes, sir.
Whatever it is.
Yeah.
All right. Now, do you understand English, sir?
A little bit.
Okay. If you understand it, I'm going to let you proceed with it without the interpreter. And then if you get stuck, just let me know.
Okay. Thank you.
Thank you, Judge. You understand that the effective annual discount rate applied to this transaction is 11.33%. If this had been a loan, that would be the interest you'd be paying on that loan. Do you understand that?
Yes, sir.
Great. And can you explain to the court why you believe that this transfer is in your best interest?
I'm gonna use it just for buy a pickup truck for the ranch, and the rest of the money I'm gonna use it for the fence and corrales for the cows.
So you need the access to this money immediately.
Yes.
Okay. I don't, and just to confirm, you know that I'm not here representing you. I represent JG Wentworth Originations LLC, right?
Yes, sir.
I don't have any other questions for the witness, Judge.
Mr. Gonzalez,
Monday, sir.
do you need the money that you receive now? Do you receive it monthly?
Monthly, yes, sir.
How much do you receive monthly?
500.
Okay, you don't need this money to survive or to live, do you?
No.
That's just extra money for you.
Yes, sir.
Okay. All right, and you actually have cattle in your ranch. You have cows,
Yes, sir.
and you do sell those from time to time. You make money off of that.
Yes, sir.
So this will help you continue making money off of your cattle sales, right?
Yes, sir.
Very good, sir. Okay. I'm going to go ahead and have you approve your application for the sale of this annuity. And I find it to be in your best interest and that you do it knowingly without the representation of counsel, and that you understand that Mr. Davila and the firm that he stands in for represents only the buyer and not you, and that you continue to proceed with it and you feel comfortable doing it. Thank you, sir. It is approved, and I'll sign off on that. Do you have them there with you, Noemi?
Yes, Judge, I have it.
All right, I'll sign off on that as soon as I get it, Sergio.
I appreciate it, Judge. I have another one, but some people were ahead of me in the line, so I can proceed however you want, Judge. If you want, I can call the next one. It's for a different client and a different annuitant, or you can proceed down the chat in the normal course of business.
Let me see. Let me continue with the chat, and I'll call you right back.
Thanks, Judge.
I'll be right back with you, sir. Which one is yours? The next one. Just so I know.
The otro is 11433, and that's for Peachtree.
Okay, I'll be right with you with that. I'm going to mark it down here.
I appreciate it, Judge. I'm going to go on mute.
Hello, sir.
Mr. Gonzalez, you can go now, Mr. Gonzalez.
Oh, okay, thank you.
Yes, sir. Good luck to you. All right, Juan Garcia, with regard to Horacio Gonzalez.
Good afternoon, Your Honor.
6781, cause number 6781.
On this case, Your Honor, we need a reset, Your Honor. There was some information. I had provided a proposed order on the last court, Your Honor. There's some acreage that is missing to complete the full acreage on that property. I asked Howland to send me that information and to send me also a proposed plat and where are all the acres, Your Honor. Once I have that, I can send it to the other parties.
What's your timeline on that?
I asked them, Your Honor, they haven't given me a timeline. They had some problems. It's been difficult getting a hold of them. I called them, emailed them. They do respond, but they do take a while. They did tell me last week that they would send me that information, but they didn't send me when.
Okay, who else is here on that case?
David Garcia, I'm here for the Paredes.
Ron Rodriguez for the Torres heirs.
And Donato Ramos, Your Honor, for Texas Land and Energy.
Your Honor, Guillermo Garcia on behalf of the Carrillo Group.
We've been basically just waiting, Your Honor, and I wish Mr. Garcia would draft a partition document. He can always leave Exhibit A for the legal descriptions, but we don't get anything, and without.
I thought that the partition document had already been rough drafted by the late Luciano Rodriguez.
It was, Your Honor, and I had to make some changes to update it to the new mediated settlement agreements. And I believe I did forward it to them about a month or 2 months ago.
So you have it, according to Mr. Garcia, Mr. Ramos.
I can resend it.
We did get it, but it's very deficient. That's the point.
So some of the tracks were lost. The highway was widened after the date of that old partition.
Right. So no one is going to have those tracks because it's gone to the state. So why don't you also, help out, like, send in some language that perhaps he can, put in this language on paragraph 2 or put in this language on page number 3, paragraph 4, or whatever it is, and just sort of help out with that so that we can get this done, because otherwise we got 4 or 5 lawyers here with their clients, like not being able to close this thing out because they're waiting on one person to finish the whole thing. I would suggest that you all try and do something and try and help out so that we can close it out. I mean, if you want, I can appoint a drafting lawyer to do the work for you, and then just bill the estate so that we can, and then there'll be less money given to each one of you, each one of your clients that's left over. I think there was 50 or 60 some thousand dollars that were left.
I guess my thought, Your Honor, was to give Mr. Garcia X number of days to draft it and then make reference to exhibits. And if not, I think your suggestion would be fine. It just, we need closure, Your Honor. And this thing has been on the docket, I don't know, 9 years, maybe more.
I understand that, but believe me, I'm ready to appoint somebody now. If you don't want to get it done, if you all can't get it done on your by yourselves, and I know that some of you are used to drafting those type of things, and some of you are not. Some of you are just trial lawyers, and some of you are. I know that Mr. Ramos, you've done some of that. Mr. Garcia, David, you've done some of that, and I don't know about the rest of you, but I know that. But I know I can. People used to use Pete Science when he was still practicing. People used to use Mr. What's his name? Mr. Juarez. Locally, there's other folks that we can come up with, but I think it's just a matter of just getting the document drafted and circulated. As long as you get that information that you all need from that acreage that, one, like Mr. Garcia said, David, that is some of those tracks at the beginning of at the front of the highway that are lost, and then the other one would be the acreage that was missing, and I think that's what Mr. Rodriguez, Ron, alluded to from the very get-go.
The other thing, Your Honor, is there's no provision for easements, and easements, as you well know, are critical in a partition. So I still would like to give Mr. Garcia an opportunity, unless he feels he just can't do it. Then, the court's suggestion is fine.
If we could agree on the tracks and the configurations of the tracks, drafting the instrument will take a couple of hours. That's the easy part. I just don't know who gets what. That's the harder part.
Well, yeah. Well, then in that vein, let's talk about that real quick, Mr. Garcia. So is there, and I guess it's a little surprising because then it's not just a matter of drafting. It's basically like, okay, from what's left, I think everyone has an idea to who gets what, but you're talking about the details of who gets what is what you're talking about, Mr. David Garcia?
Yes, Judge. And the thing is that document that Mr. Luciano Rodriguez drafted long ago. So my clients lost the little track that they had on and I'm not going to say east or west. I'm going to say on the right-hand side of the highway. I don't know how helpful that is. I don't know if I'm going by memory. I don't remember if the map was upside down or whatever. But when I saw it, it was on the right-hand side. So I'm assuming it's on the east side. And so that track's completely gone. So I guess the question is, and I'm kind of new to this, the question is everybody going to get the pro rata share of acres? Or are some people going to get less than their pro rata share because what they had originally contemplated, those acres are gone? And if everyone's going to get the same acres, well then those tracks are gone, right? So somehow or another, we got to recarve the way the tracks are going to look. Probably based on what we originally had, that would be easier, right? Just move everything around a little.
All right, guys.
That's the question. Who gets what? That's the harder part. I mean, as far as drafting the document, it's very simple. Let's do it in one day.
Okay, we need to get that down. So I think from here to October 22nd at 1:30, you all need to get that squared away. And if it's not squared away, then we need to square it away. We'll give a setting to the court so that we could square it away. And I don't know if we can square it away without having to go through the whole, commissioner bit. And so I would hope that you all want to avoid that type of cost.
We do.
So let's get that squared away, because it looks like we're a little bit further than what I thought we were. Let's get that squared away. Who owns what? I think we're going to keep it simple like that, like Mr. David Garcia is saying. Who owns what? Let's get everybody to agree, okay? And I thought we had already gotten there, but who owns what? Get that squared away, and then the drafting hopefully can happen within 2 or 3 weeks after we know who owns what. Now, it concerns me that Mr. Ramos is saying, well, what up, those documents didn't contemplate easements. Well, geez, if you already had Howland going in there, those easements I don't understand how they couldn't have already contemplated easements if there was already contemplating a partition even way back then.
And of course, as you well know, Your Honor, if there's going to be easements burdening the tract, somebody may say, well, wait a minute, I didn't want a road on my tract and so forth. So a lot of the detail is up in the air.
Well,
I represent an intervenor, actually.
That's not good, because quite frankly, we're back at square one if you're going to call it that, because now you're saying, well, I have a loss of value because I have a burdened tract, and therefore I could get more acreage because of the fact that I got a road going through my acre. Well, that's square one stuff.
I agree.
That's not good. That means we've been spinning our wheels here for a few years.
I'm new to the case, Your Honor, and I noticed that from the very beginning. My client has a very small interest, and we're an intervenor. We may actually seek a severance, Your Honor, if they can't agree. We're a small player in this whole thing. So I don't think it's fair for my client to bear all of the expense of all of the drafting. It seems that the plaintiff who brought the partition suit should take the initiative.
Mr. Rodriguez.
Yes, sir.
Do you have a question with regard to the proposed easements?
Well, I don't know if I have a question, but I'll tell you, I'm an intervener too. So I'm not the plaintiff that brought the case, but I will tell you that I've been out there, Judge, to the actual tracks. And there is I don't know if it's a private road or a public road, but that runs adjacent all the way through, at least to my client's property. So I don't know if that's already included as an easement or not, but that road, it's a caliche road that appears to go through most of the tracks, or at least through mine. So as long as that can be, put in there as an easement, we have access to our property, so that's not an issue for my clients and their tract.
Well, what Howland has now should have the existing easements. Should it not, Mr. Juan Garcia?
It should, Your Honor. However, they were having some problems, but there were some acres that were missing. I don't know why they got lost. That's why I asked them to give me an accounting of all the acres.
All right, guys. I think you all need to get started. If you don't get anywhere by October 22nd as far as who owns what, let's get this thing kickstarted with ground zero with commissioner stuff, because otherwise we're going to be like this, spinning our wheels, and we're never going to finish it. I have an obligation now that I know where we're at, to get it moved. I don't think we ever did appoint any commissioners, did we?
I don't think so.
Your Honor.
Oh, I don't think so, Judge.
I may just get that started if we don't make any movement by October 22nd.
That's fine.
Thank you all. We'll see you then.
Thank you, Your Honor.
Thank you.
Mr. Pepe Garza.
Yes, good afternoon, Your Honor.
Good afternoon, Mr. Garza. From 11 through 82. Juan Garcilaso versus Hilaria Garcia.
Yes, Your Honor. We served we provided the trial dates to opposing counsel. We provided 3 different trial dates, and we also filed our jury demand. We're just
Is
waiting.
anybody here for Carlos Castillon's office? Anybody here for IBC Bank?
Your Honor, if I could, Rudy Santos on behalf of defendant Hilaria Garcia, Mr. Castillon, and the president of IBC have both been dismissed, I believe.
Okay. Okay, so then have you already signed off on the guideline order?
Judge, we're about to do that. We recently got some proposed dates. We have a date picked out, but I would want to make the court aware of the fact that we filed and our summary judgment was accepted this morning. It's been served as well. We would ask for a setting on that.
So you filed the traditional motion for summary judgment?
Traditional and no evidence, Your Honor.
No evidence is not going to be set because it's way too early. We'll sign off on a setting for a traditional, but you just filed this lawsuit in May. There's an absolutely no discovery made, hardly any. So I can't set your no evidence.
The traditional sign, Your Honor, we feel pretty confident about it.
All right. Noemi, go ahead and assuming that you received that, let's go ahead and we're going to pass this case for a counter call sitting on November 1st. And then at 1:30, and then just get Mr. Santos's summary judgment set for a day prior to that. And then we'll see where it goes. Noemi?
Yes, Judge.
Thank you. Okay. Donald Dixon, 11-228.
Thank you, Your Honor.
Good afternoon, Your Honor.
Good afternoon. Velocity Investments versus Jorge Caso. There was a service on Jorge Caso on March 10th of this year. Could I confirm with the clerk's office that there has been no answer? Irene or Elva, Silvia?
Judge, no answer.
There is no answer.
Service on March the 10th.
Thank you.
Yes, sir.
Anybody here for Jorge Caso? All right. Anybody who's here for Velocity?
Your Honor, my name is Donald Dixon. I'm an attorney in Austin.
Mr. Dixon, you want to proceed?
Yes, thank you, Judge. This debt arose from a $30,000 promissory note executed by Mr. Jasso with WebBank. The account has been transferred twice. Velocity Investments is the assignee of Prosper Funding and WebBank. The account was charged off in 2019 in the amount of $22.76. We are also seeking $2,402.27 in attorney's fees. There is an attorney's fee affidavit on file with the motion for default judgment, and the other requisites of the default judgment are also proper in form. There's a certificate of last known address and a certificate of non-military service.
Thank you, Mr. Dixon. The court takes judicial notice of the entire file. The service is made. There is no answer. The proper prerequisites are on file with regard to this default, and it will be granted in the manner which has been requested. I'll sign off on your judgment, assuming that you have one in there, Mr. Dixon.
Thank you, Judge. I was going to ask if the court had a copy.
I have it, Judge.
We have, Mr. Dixon. Thank you.
Very good. May I be excused, Your Honor?
You're excused. Thank you, sir.
Thank you for your time.
Julio Garcia for Estela Ramirez versus the heirs of Bustamante.
Hi, good afternoon, Judge. This is actually Mr. Ricky Solis's case, Judge. I'm an ad litem on this matter.
Okay,
It's
you're
an
the
adverse possession case.
Okay, where is that at, Mr. Solis?
That's cause number 11,400, Estela Ramirez versus the heirs of Bustamante, Your Honor.
Okay,
I put that on your chat.
thank you, sir. All right, citation by publication, Mr. Julio Garcia has been appointed ad litem. And the court takes judicial notice of the entire file. The fact that service was effectuated by publication, that there was a return. You may proceed.
Yes, Your Honor. I think Estela Ramirez is on, she's
Estela
on Zoom.
Ramirez. Estela Ramirez.
She was on Zoom, Your Honor.
Give me a sec. I see you there. Just unmute yourself, Ms. Ramirez. Hit the mic button. There's a little button that's, there you go.
There you go. Are we ready, Judge?
Yes. Ms. Ramirez, please raise your right hand.
Yes, sir.
Do you swear testimony you're about to give here in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, Ms. Ramirez. You can put your hand down now.
No,
Proceed.
this is cause number 11,400, Estela Ramirez versus the heirs of Habitación Bustamante. Ms.
Proceed.
Ramirez, will you please state your name for the record, please?
Estela Ramirez.
Are you the same person who filed a lawsuit for a quiet title?
Yes.
Okay. Are you claiming a certain piece of property which is described as all of lots number 3 and 4 in block number 59 of the new town of Zapata in accordance with the plat of said town
Yes.
of record in volume 2, page 127 of the map records of Zapata County and supplemented plat thereof in volume 2, page 133 of the map records of Zapata County?
Yes.
Okay.
Yes, sir.
You currently live in Zapata?
Yes.
Do you know the whereabouts of the defendants in this case, ma'am?
No.
Okay. Can you tell the court how long have you been using this property?
25 plus, almost 30 years.
Okay. And have you been paying the taxes on this property?
Yes.
And can you tell the court how have you been using this property?
Well, I used to have a medical supply and I used to use it there for that purpose. And then I use it for my personal things. And I've been using it all this time. I've been cleaning the lots and fencing it and paying taxes and everything.
Okay. And has anybody ever told you to leave the property?
No, never.
Never. No one has ever told you you have to leave this property because it's not yours?
You know.
No, never.
Okay. And you want the court to award you this property?
Yes, sir.
Judge, I think you're taking judicial knowledge of the citation and how many times it's been publicized. Is that correct, sir?
The court takes your, are you done with your testimony?
Yes, sir.
All right, anything from the ad litem?
Your Honor, I had an opportunity to speak to Ms. Ramirez. Everything that she testified is correct. I've looked into the errors of Mr. Bustamante. My understanding is that he has passed. I know that Ms. Ramirez has been paying the taxes. She's been working and being active on the lot. There's a fence around both of these lots. I know that she's used it and has had nobody asked her to move from those properties. We are in agreement with the, we believe that she satisfied all the requirements for the adverse possession under Texas rules, Judge. We have submitted the signature of a judgment that Mr. Solis has sent to me, and we're requesting this court to approve the petition and request and award Ms. Ramirez these properties, Judge.
Thank you, Mr. Garcia. The court will take judicial notice of the entire file. The service, the return, the appointment of the ad litem, the testimony of Ms. Ramirez with regard to her continuous use of the property for the minimum amount of years that is allowed, that is required by this particular part of the statute. the taxes that have been paid on the property by Ms. Ramirez, as her testimony will indicate, the fact that she used this adversely to the world and publicly to the world will in fact now allow me to in fact grant her application for the adverse possession petition and grant her title as such. Thank you, Ms. Ramirez. We'll sign off on the petition. Did you submit the judgment, Mr. Solis?
I will do that, Your Honor. I was just waiting for Mr. Garcia to sign it so I can sign it, and I will e-file it to the court.
Entry of judgment then September 15th, but you can do it sooner.
Yes, sir.
Thank you, Mr. Ramirez.
Thank you, Your Honor.
That's
Ma'am,
all I have,
excused.
Your Honor. May be excused.
Yes, thank you all.
Thank
Real quick on that tax case from this morning, Jimmy Gonzalez, Mr. Mario Garza,
Yes, sir. Good afternoon, sir.
10-755. Mr. Garza, hi, how are you? Mr. Garza, you know,
Fine, sir.
this is a rental property that you own, and you've been making these $500 payments. Mr. Gonzalez, how much did you say he owed still?
There are several tracks, Your Honor. He owes a total of $37,533.
$37,000, Mr. Garza, on several of these tracks. And the $500 a month that you're paying probably doesn't even cover the interest that is accumulating on these properties. So I don't know what you.
Yeah.
I don't know what you intend. If you understand that you're accumulating more and more debt every single month.
Sir, but when I started this to pay, make the payments, it was back in like 2 years back, and before that I didn't pay payments, nothing. But I've been since these 2 years I've been starting to pay, and I haven't missed a payment. I've been paying all I can, sir.
Do you have any of those properties rented?
No, sir. But I'm looking forward to renting another rental I have, so I could get more, so I could make some more payments on it, sir.
Well, why don't you try and why haven't you tried to rent them sooner or get a
No, sir.
loan?
Well, it was my dad's house, sir. He passed. It's a real hard for me, you know, and all this. But I it's something that I have to be done, and I'm gonna do that, sir, as soon as I can. But every month I've been paying since this. I have started to pay. I've been trying my best to do this, sir. And
let me ask Mr. Gonzalez, what is it? How much accumulates a month on a debt like this?
I mean, it's, you know, Your Honor, I can't tell you exactly, but I mean, it's close to $500. I mean, I could tell you, Judge, that what happens also if the court would take judgment on these cases, I mean, we still work out payment plans. We still work out payment agreements with the taxpayer. We only have one tax sale a year for Zapata County. So it's not like these properties, if they would go to tax sale at all, would come up next month. The earliest it would be early next year. So, I mean, and if he's making payments, we'll still work with him. What my concern is that the payments he's making, and he has been consistent, are only covering barely interests. And he's made a great effort, and it clogs up your docket, Your Honor. And we keep coming back every 5 or 6 months for the same thing. If we take judgments, it'll be off your docket, but we will continue to work with Mr. Garza in a good faith effort.
Mr. Garza.
Yes, sir.
You hear Mr. Gonzalez saying they're not going to be selling the property anytime soon or putting it up for sale as long as you keep on entering into if you enter into a contract with them to pay and you pay the way you're supposed to. So yes, that's what I'll order for you all to do. Basically, I'll take the judgment for the amount of money that is owed, the way that they have said, and you're supposed to get credit for everything that you've paid. So you'll get credit for all that. And then you will you'll go to the tax office and enter into an agreement with the taxing entities to make all these payments on a monthly basis, on a contract basis.
Okay,
and then
sir.
As long as you're paying that way, they won't sell it, you know?
Okay, sir. I just wanted you to know I'm doing the best I can. I don't have a job. I have a few cattle, not very much. They're reproducing. Next month, I should have some steers for sale, sir. I don't have much, but
I understand,
could give.
but the tax office has already said that they'll enter into an agreement with you so you
Okay,
can make the payments, and then as long as you make those payments, you can keep on paying, okay? And they won't sell it.
Okay, sir. I really appreciate it, sir.
Thank you, sir.
Thank you, Your Honor.
Can I be excused?
Yes, sir.
Thank you, Your Honor. Have a good
Can I be
day.
excused? Can I be excused, sir?
Yes, sir, Mr. Astor.
Okay. Thank you, sir. Have a nice day.
Thank you, you too. Benito Salinas, 10873. I'm not sure where that is.
It's from this morning's judge.
Oh, okay. Benito Salinas is pro se.
Aquí
Yes,
estoy.
Judge.
Mr. Salinas,
Mande, aquí estoy, juez.
Yes, I'm here, Judge.
have they been served? Clerk's office? Oh, yeah.
Yes, Judge.
And what is it that you want to modify, Mr. Salinas?
Señor Salinas, ¿qué es lo que usted quiere modificar?
Oh, la custodia de mis hijos.
My children's conservatorship.
And where are the children now?
¿Y ahorita dónde están los niños?
Oh, están conmigo. Bueno, ahorita están en la escuela, digo, pero están viviendo conmigo.
They're with me. Well, right now they're at school, but they're living with me.
And how long have they been with you?
¿Y cuánto tiempo?
Without mom?
Ya van para 4 meses. Mijo.
It's going to be 4 months.
And where's mom?
¿Y dónde está la mamá?
Se juntó con un muchacho y se fue.
She got together with a young guy and left.
And she left Zapata, or where'd she go?
¿Y se mudó de Zapata o a dónde se fue?
Sí, se fue de Zapata.
Yeah, she left Zapata.
And how many children do you have?
¿Y cuántos niños tiene usted?
Tengo 2. Tengo mi niña y mi niño.
I have 2.
And
I
how
have
old are
2,
they?
a boy and a girl, the
No,
little couple. ¿Y qué edad tienen?
Mi hija tiene 5 y mi hijo tiene 6.
My little girl is 5 and my boy is 6.
All right, so service was accomplished on July 13th, clerk's office.
Yes, Judge.
She has not filed an answer.
No, Judge.
Is Benito, I'm sorry, what's her name? Stephanie Chapa, are you present?
Stephanie Chapa está presente.
Traté de comunicarme ahora con ella y parece que no está. No
I tried to communicate with her today, but it doesn't seem like it.
So the kids had originally been awarded to her?
Entonces ella tenía la tutela de los niños al principio.
Yeah.
¿Se le designó a ella? Yes.
Yeah.
All right. So you're asking to become managing conservator of the children and her to be possessory conservator, and you will determine the residency of the children. And then we'll eliminate your child support, and she will pay child support in the amount of $275 a month.
Muy bien, entonces usted está pidiendo la tutoría de los menores, donde usted va a designar donde ellos vivan y ella tenga el derecho de visita según la amplitud que el juzgado conceda, y ella se le va a pagar, ella va a tener que pagar la manutención alimenticia en la cantidad de $275 al mes.
Yo ya no quisiera nada realmente, yo nomás quisiera que mis hijos estuvieran conmigo.
I honestly don't want anything. I just want my children with me.
I understand. You can tell her that was not your decision, but mine.
Entiendo eso. Usted le puede decir a ella que eso fue mi decisión y no la de usted.
Ok, no, está bien, disculpe.
Okay, I apologize.
But now I need an order, so you need to prepare an order.
Pero ahora necesito una orden. Necesito que usted prepare el documento o esta orden.
So you will have until July 15th to get that document to me.
Entonces le voy a dar hasta el 15 de julio.
I'm sorry, September 15th. Yes, September 15th at 1:30 to get that document to me.
Disculpe, la fecha será límite para que usted entregue este documento al juez el 15 de septiembre a la 1:30 de la tarde.
Perdón, ¿y ese documento como que es o qué?
And that document, what is it or what?
You'll get it from the same place you got the document that you filed to be able to start this lawsuit.
donde usted fue para conseguir este documento para empezar esta demanda, vaya a ese mismo lugar para que le den este documento.
Ah, ok, está bien, muchas gracias.
Okay, very well. Thank you very much.
Thank you.
Gracias.
Okay, Humberto Treviño from this morning also.
Yes, Judge.
Yes, I'm present, sir, Your Honor.
Okay, where are you at, Humberto? Humberto, where are you?
Yes, Your Honor, present.
Okay, what is it that you're seeking, Humberto? What page is he at?
Excuse me?
What page is he at, Noemi?
Page 8, Judge, the last page from this morning.
And he's seeking what, a divorce?
Yes.
Yes, Your Honor.
Is there service?
Yes, Judge, by publication, Judge.
Is there return on file?
Yes, Judge.
Thank you. When was it served? When was it served?
We got the affidavit on August the 9th, Judge.
Okay. Mr. Treviño, where are the children now?
Really, I do not know, sir.
Okay.
I know they're in Texas.
Okay, so you all have been, okay, please raise your right hand and be sworn. You swear testimony you're about to give here in this hearing will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir. Yes, Your Honor.
Are you seeking a divorce?
Yes, Your Honor.
You can put your hand down now. And
Yes, sir.
you're seeking that the children are going to remain, what are you seeking? The children are going to stay with her? You're going to pay child support? What are you looking at?
Yeah, I'll pay child support if she wants to. I mean, don't matter.
She's not here. Have you?
I know she's not.
Do you have a do you have an attorney general case?
No.
Do you have a child support case with the AG's office?
No.
Okay. All right. So you're seeking this divorce from her, and you're seeking that you all be joint managing conservators, and that she would be the one that determines the residence of the children, and you'll have a standard visitation right? You're going to have standard visitation rights?
Yes, Your Honor.
And child support, how much are you paying right now? You don't know? Have you paid anything?
No, Your Honor. No, not yet, Your Honor.
Do you know where they're at?
No, Your Honor. The only thing I know is they're in Texas.
How long have how long have you not known of them?
5 years, 4 years.
My goodness.
It's been a long time.
How old are your children now?
My son is 15 and my daughter she's 12. Turning into 12.
So you don't have no idea where they're even at?
No, sure. I think they're in Texas. I know they're in Texas.
No idea what to do here. All right. The divorce will then be granted as a result of the fact that your marriage is becoming insupportable as a result of conflict of personality between you and your wife. Both will be appointed joint managing conservators. She will determine the residency of the children. You'll have standard visitation rights. You only have personal property, and she only has her property. You have yours, and that's it.
Yes.
All right. Each party will be awarded the personal property in their possession and control. Submit the decree by September 15th at 1:30, sir. You need a document that reflects this divorce. Thank you, sir. We'll see you then.
Thank you, Your Honor.
September 15th at 1:30.
Thank you.
Lawrence Valley.
Permission to dismiss?
Yes, sir.
Good afternoon, Your Honor.
11/3/38.
Your Honor, I'll be very quick. I know you're a very busy man today. I represent Caterpillar, the plaintiff. No defendants have answered yet. We've only served one of the three defendants, Adula. We filed a motion for interlocutory default judgment, and we're in the process of serving the other two. I would suggest to the court, perhaps we enter and continue my motion for interlocutory default judgment and reset this for a status on the service of the other two to save time today.
That'll be granted.
Thank you, Your Honor. May I be excused?
Yeah, do we need to give you a date on the other ones?
That would be perfect.
Let's check for October 22nd, see how you're doing there.
Very good. Thank you, Your Honor.
Thank you. Give me 1 second, folks. Okay, so that was, I think I skipped some. No, it was Mr. Trainer, Philip Trainer, 11390.
Yes, Your Honor.
Good afternoon.
We are working on service on this. We apparently had a bad address. The sheriff informed us last week that when they went out to serve, it was an empty lot. We're running a skip trace to try and get a better address and just need some more time to get service completed.
I'm going to give it to you November 1st at 1:30.
Thank you, Your Honor.
Thank you. Let's see. I'm trying to, we got Chris Miller, 11001. Lopez versus Lopez.
Present, Your Honor.
Who else is here? Well, aside from Mr. Miller, I think it's Mr. Davila, Mr. Payne.
Yes, Your Honor. Chris Payne here on behalf of the plaintiffs. I thought I saw Mr. Davila.
Emilio, I can't hear you. You're muted, Mr. Davila. Emilio. Okay. I got you. Okay, so I got Mr. Miller, Mr. Davila, Mr. Payne. Not sure who else needs to be here.
That should be it, Your Honor.
Okay.
What we have, Judge, is this is our final pretrial hearing. And we're set for, I believe, a bench trial on September the 13th.
I think we were told that's being passed, Your Honor, for some reason.
Well,
I don't let's see.
Well,
Me?
Yeah, I got a call from Miss Naomi, I think on Thursday of last week, and she said that the September 13th date was not going to be available, Your Honor, or it was going to have to be passed, and she asked if we wanted to continue with this hearing. And I said, yes, we do. Because
I'm sorry, Mr. Payne, let me ask Noemi. Noemi, you know anything about that?
Judge, the September 13th is our trial week. And I wasn't sure we're gonna do a trial.
No, yeah, we don't have juries all of September. I think that's why she probably said it's probably going to be passed, because she thought we were going to have a jury trial. No, we don't have juries, and as a result of that,
Your Honor,
ours is a bench trial.
Are you all ready to go?
We're ready to go, Your Honor, on September the 13th. If that's agreeable to the court, we'll proceed on the bench trial. If I don't know if that's acceptable to counsel for the plaintiffs.
It's acceptable to us, Your Honor. We had a pending motion for summary judgment hasn't been ruled on yet. That would help kind of streamline things. But other than that, we're ready to go.
On that MSJ, it's on what issues?
It's on the issues of, this is a deck action, Your Honor. And we believe that the law is pretty clear on this, so the facts, at least as far as the declaratory judgment,
I thought I heard you say that it would streamline it. If you're saying it's a deck action, it wouldn't streamline it, it would dispose of it.
It wouldn't dispose of it, Your Honor. There is an action for damages on breach of fiduciary duty, but the deck action involves the court. There's a dispute among the parties about whether the law allows for this type of fiduciary duty. So it could dispose of it depending on the ruling. If the court finds there is a breach of fiduciary duty, though, it would wipe out the deck action and we proceed solely on the breach of fiduciary duty and waste claims. But since there's a fight over what the law is, clarifying the law, which would streamline how much argument and stuff you have to deal with on the 13th, Your Honor.
Okay. Do you all have, because I don't have my notes here with me, do you all have the date of when that MSJ took place?
I believe there were two hearings. There was one on April 13th, another one in May.
And the court took it under advisement, Your Honor. It's a no evidence motion for summary judgment by the defendants, Mr. Lopez, that's pending before you. You've heard argument on and so this case has not been mediated. I don't know if that's a problem for the court.
Well, it's because I usually do like to have, I mean, not usually, that's basically standard nowadays. It's like, I'm not going to take up more than a 2-hour hearing unless you go to mediation. So if this is more than a 2-hour trial, then it has to go to mediation.
It would be more than a 2-hour bench trial, Your Honor. And so if the court is inclined to pass it, the only thing that I would ask is that that you appoint whoever you think is next on your list, Your Honor, to mediate it so that we can get that done promptly. And if we're unable to resolve it, then if you can give us a date, a definite date for a bench trial sometime after September the 13th, Your Honor.
Your Honor, first point of clarity is that there's a no evidence and a traditional motion for summary judgment. That's why I presented it the way I did, Your Honor.
the traditional issues have to do with the legal issues that the parties are disputing. But anyway, the only thing I'll say, Your Honor, is this is a father versus two sons. It's a very acrimonious relationship. I'm not sure mediation is going to do any good, especially based on the deposition testimony of the father who Mr. Davila represents. It seems intractable. And without that, it's a little hard to get there. And our clients do want to go ahead and get going with trial. If we're going to do it on September 13th, let's do it.
I will, I'll tell you this. If you tell me how many witnesses, because I mean, as it looks now, that day looks open for me, which is kind of weird, but it does look open. If you tell me how many witnesses you anticipate, Mr. Miller, and on your side, and how many witnesses you anticipate on your side, Mr. Avila, Mr. Payne, and then I can tell you whether or not I will have the time to get that done.
There's 2 to 3, Your Honor. My anticipation is we get it done in a day at the most.
Mr. Avila, on your side.
When he says 2 or 3, I guess he means the 2 sons and who else?
We might be calling a real estate agent that was involved in the property. But that would be a very quick witness, Your Honor, talking like 10 minutes maybe.
Okay. I don't know if, all right, well, that's fine.
I'm not holding you to the number. I'm just trying to get a guess.
Yeah, and we would have just Mr. Lopez and perhaps Mrs. Lopez, Your Honor, and that's it.
Oh, both Mr. and Mrs. Lopez are defendants?
No, just Mr.
No,
Lopez. I think he's talking
originally
about
they-
the new wife.
Originally, they had sued Mrs. Lopez, but they've dropped her, Your Honor.
Oh, I see. Okay. Okay, and I will get back to you with regard to the MSJ, and then I'll ask you to get ready for September 13th unless you hear from me otherwise.
Yes,
Thank
Your
you.
Honor.
Your Honor,
Yes, Your Honor.
if you don't mind, I forgot to put my name on the next chat room announcement. That's my case,
Yes, sir.
10717.
Okay.
But so just for purposes of Lopez v. Lopez, may we all be excused?
Mariel, we're done with Lopez v. Lopez. Now we're over here with 10717, Mariel Socorro Lopez versus Salt Creek Productions.
Thank you, Your Honor. Chris Payne for the plaintiffs. Your Honor, Mr. Stevens and I have been working on a settlement agreement, as you know. We were able to, Mr. Stevens was able to get a release of lien from the power company that had placed a lien on the property. There's just one more issue, which, obviously we agree with. There's just one more issue with respect to the pipeline itself, Your Honor. Salt Creek had operated that pipeline. Where's, Ms. Earls is looking for some sort of indemnification. We think the indemnification is in the agreement. But Mr. Stevens and I have agreed to go ahead and try to get the pipeline hydrostatically tested to see if it's still a viable pipeline, and if so, whether or not there's any leaks. And so, and then the only issue now is just who's going to pay for that hydrostatic test. So we'd ask the court for another setting, another calendar call, so to allow us to find the company that's going to do it and just secure some more information about the hydrostatic test.
Okay. How about that? No, I mean, if y'all in no hurry, I'd rather push you to November 1st. See what.
That's fine with us, Your Honor.
All right, November 1st then. Send notice to Mr. Stevens, Noemi, please.
Yes, Judge.
Thank you.
Thank you, Your Honor. May I be excused?
Yes, sir.
Thank you.
May I be excused, Your Honor?
Yes, Mr. Elliott, I'm sorry. Yes, of course.
Thank you, Your Honor.
I'm not sure, but I think I have Ramiro Garcilaso. Is that from this morning? Mr. Garcilaso?
Judge, he wasn't on the docket.
Okay. Did you tell him to come back another day?
No, I think you had asked Dora to put it on the docket for today.
Okay, well, then was he on the docket for today?
No, but I sent you the order.
Okay, so cause number 11375, Ramiro Garcilaso III, ahí estás?
Yes, sir, I'm here.
Okay, sir. Please raise your right hand and be sworn. Swear testimony you're about to give here in this hearing will be the truth, the whole truth, nothing but the truth, so help you God. Yes or no, sir?
Yes, sir.
Okay, do you have the file ready? Who is it down there? Is it Celia or Irene?
Let me look for it, Judge. Hold on, please.
Elba? Yeah, I'm sure. It's okay. Wait a second, Mr. Garcilaso, please.
Yes, sir.
I'm almost there, Mr. Knudsen. Give me a second.
Okay, Judge.
Okay. Can you check the file to see if it's ready?
It's ready, Judge.
All right. The court would take judicial notice of the entire file, the fact that all the entities that Mr. Garcilaso wanted served were served, that acknowledgement were received, that no one has filed an answer. Is that correct, Irene?
That's correct, Judge.
All right. And Mr. Garcilaso, your testimony that you give today is that the information that you have made, that you have placed on your petition with regard to your arrest of back in 2015, that is true and correct,
Yes, yes, sir.
including the offense that happened April of 2013 as well.
Yes, sir.
And that on both of those cases, you were arrested by the Zapata County one by the Zapata County Sheriff's Office and one by the Laredo Police Department. And that in none of those, on those two occasions, nothing happened. You were never sent to court. You were never placed on probation. Is that correct?
Yes, sir.
And since then, you have not been charged with another felony, sir?
No, sir.
All right, very good. Then I will grant your application for expungement. I'll sign off on the order. I'll take judicial notice of the entire file.
Judge, if I may.
Oops, I didn't know you were there, Pete.
I'm here, Judge.
Yes, sir, go ahead.
Well, I mean, the only objection was that the one from Laredo, Webb County, he got placed on deferred. He completed his deferred.
I didn't say that. That's not what it says here on this one. It says no action. Which offense are you talking about?
It's the very first one, the 03. I have a cause number.
I don't have an 03 here. He's asking for an expungement on an offense of an assault causing bodily injury, Class A, that occurred on or about June 7th of 2015. And then he's asking for an expungement on an offense that occurred, that was in Webb County. And then this one's in Zapata, terroristic threats, Class B misdemeanor, that occurred on or about April 6th of 2013.
Okay, so the one in Zapata, there's no objection. That was not accepted. And the one on 2015, unless Mr. Garcilaso can tell us, my notes show that happened in Beeville, in B County, unless I'm mistaken. If it happened in Zapata County, then there's also no objection.
Mr. Garcilaso, the offense that occurred on or about 2015, that you were arrested for a resisting arrest. Oh, I'm sorry, wait, I'm sorry, hold on a second. Nope, I make a mistake. No, the one for June 7th, 2015, it was a resisting arrest, and I don't know where it was on. Where was that one at, sir?
I don't have any documents in front of me, sir. I'm actually at work right now, and I have no idea. I think that's
Okay. We're going to reset it for September 15th, sir, so that we can get all that information, okay? So get all the information with regard to the 3 arrests and September 15th at 1:30. Okay?
Yes, sir.
Thank you, sir. Come back the same way. Okay.
There was one more expunction, Judge.
Okay.
11402.
11402.
Rene Benavides Jr.
He wasn't ready, Judge, with the order, so he asked for a reset to the 15th, September 15th.
Very good. September 15th at 1:30 p.m.
Thank you, Judge. Well, there weren't any objections on that one. Okay, thank you, sir. May I be excused, Judge?
Are you done? Yeah, because I think we got.
Yes, sir, I believe I am.
Thank you, Mr. Garza.
Thank you, sir.
Okay, back to our civil docket. We got Kevin McGuire, 11-348.
Yes, Your Honor, I'm present for Ford Motor Credit, the plaintiff.
Good afternoon, Mr. McGuire.
Good afternoon.
And Ford Motor Credit versus Maria Thatcher, Jose Thatcher. They were served both on April 15th and April 17th. Are there any answers on file at the district clerk's office?
No, Judge, no answer.
Okay, is anybody here for the defendants, Maria Thatcher or Jose Thatcher? They are not. Mr. McGuire.
Yes, sir. Thank you. The defendants purchased a 2019 Ford Expedition Max on June 15, 2019 by written agreement with McCombs Ford West. The written agreement gave the plaintiff the right to repossess the vehicle in the event of default. The payment arrangement was for 72 monthly payments at $1,325.10 per month starting July 30th, 2019. The last payment was received by the plaintiff on December 30th, 2019. This was the event of default. The vehicle was then repossessed on February 18th, 2020. The vehicle was sold at Mannheim Auction House on June 17th, 2020 for $45,200. Pursuant to the Texas Business and Commerce Code, the defendants were sent notice of sale and the statement of sale by regular first-class mail postage prepaid. After all lawful credits and deductions, a deficiency amount remains due and owing in the amount of $26,811.72, for which plaintiff seeks judgment, plus court costs and attorney's fees totaling $500, reflecting 2 hours of legal work at $250 per hour. This legal work is necessary, reasonable, and customary for this case type. Plaintiff respectfully seeks judgment in these amounts, Your Honor. Nothing further.
Thank you, sir. The court will take judicial notice of the entire file and will grant default judgment as requested.
Thank you, Your Honor. Thank you, sir.
Humberto Treviño.
It was a divorce, Judge. You already did it.
Okay, good. And then we have Donato Ramos on Palmira versus Blackbeard. They said that they filed a pretrial guideline order this morning on 11-379. Donato Ramos, Roberto Hargrove, and Raymond Hafner. I'm assuming they already filed the guideline order. That's what Mr. Donato Ramos says in the chat. And then he went into Horacio Gonzalez. Erlinda Garcia, can you confirm that one on 11-379 after we finish the docket today, Noemi, okay?
Yes, Judge.
Erlinda Garcia. We did that one. That was the tax cases, no? Rosaura Herrera and Erlinda Garcia.
Yes.
Rosaura
Yes,
Herrera.
can you hear me?
Okay.
Hello?
Yes, ma'am. Are you there?
This is Erlinda Garcia. This is Erlinda Garcia.
Okay, how are you, ma'am? What case do you have? Can somebody find it for me?
It's my tax.
Yes, we did something with that already. Let me see.
It's on the tax docket 9275.
Yeah, but I think,
The first one.
did they non-suit that? Where is it? I don't know where I left it. Did they already dump the trash? I think they did, right?
You granted it, Judge,
Granted what?
the judgment.
Okay, Ms. Garcia, what were you gonna tell me about that case?
I wanted to know if you can give me a little bit more time because they had I told you that I was gonna pay the rest of the taxes when my income taxes they came in, but it's that they hold the IRS hold my income tax, and now I don't have my income tax until they finish checking my income tax. So I haven't received my income tax. I'm waiting for that. I've been giving the payments of $200. If you can give me a little bit more time
How much you
and
on?
still giving, I think I owe like 3,000 and something.
And this is on what property? The one you live in?
I happen to have a lot, have,
Half a lot.
well, not y medio, acre y medio.
Were you here this morning when I called the case? Because I called it this morning.
Yes, but like my daughter was not here and I didn't know how to go in, and I didn't know if you heard me that I said I was here.
No, we didn't hear you. Okay. So I'm gonna on 9275, set aside the default because she was actually here. Send word to Mr. Gonzalez that that's gonna be placed on the docket back on October 22nd, okay? Noemi?
Yes, Judge.
And then make the entry about what I just said. Irene, please.
Judge, I'm sorry, can you repeat it? I'm so sorry.
Yes, that I'm gonna find that Miss Garcia, Erlinda was here this morning, but she didn't know how to unmute herself, so we couldn't hear that she was here.
Yes, Judge.
And since she was here, we're gonna set aside the default and we'll set it again for October 22nd at 1:30. I'm sorry, at 9.
Yes, Judge.
Thank you, ma'am. So you need to come back onto court on October 22nd.
Okay,
Thank you, ma'am.
okay, thank
Continue
you.
making your payments. Thank you.
Yes, I will.
Thank you.
Thank you,
Okay.
Judge.
So go back on the chat. Joshua Ford on 11-3-11.
Good afternoon, Your Honor. Joshua Ford for Plaintiff Capital One Bank.
Yes, good afternoon. So we have Michael Moss, plaintiff, attorney for plaintiff, and Karina Garcia who came in pro se. So you are now handling this case. Tell me your name again? Joshua Ford.
My name is Joshua Ford.
Yeah. So Karina Garcia, are you present? Check when she last, we're set for bench trial today, in fact. Let me just confirm that
Let me check, Judge.
that she got notice of the bench trial setting. Noemi. Irene. Thank you.
Your Honor, our office did also provide notification to the defendant on the 25th of August.
Thank you.
I emailed it to her, Judge, on August the 20th. I sent her an email.
Very good. That's the email you got from her, yes?
From her, yes, when she filed an answer.
Okay, you may proceed.
Thank you, Your Honor. This is a debt claim case regarding original suit brought by Plaintiff Capital One Bank, original creditor. We're seeking judgment in the amount of $4,541.03 plus cost of court. We are not seeking any attorney's fees or post-judgment interest in connection with this matter. This account was opened by the defendant on or about September 30th, 2014, and was charged off by the plaintiff on or about August 23rd, 2018. The last payment that was made on this account was on March 1st, 2018. The amount of that payment was $545. The defendant has not appeared today, and we do not have record of any answer on file with this defendant. We did file a motion for default judgment back in May of this year, May 5th, 2021. In support of that motion, we attached a business record affidavit signed by an account representative with the plaintiff attesting to the accuracy of the balance at time of charge off. We also attached a copy of the final statement showing that balance at time of charge off, along with a copy of the Service Member Civil Relief Act affidavit verifying that the defendant is not in the armed forces, as well as a certificate of last known mailing address.
Thank you, sir. The judgment will be, the court will take judicial notice of the entire file. The fact that there is no answer, that she was served, that there is no answer on file. That notice was given in any event of this bench trial date, and she did not appear. Judgment is granted. Please submit your, you do have the judgment on file, and I'll sign off on that. Thank you.
Thank you, Your Honor.
Back with you, Mr. Davila.
Permission to be excused?
Yes, sir. Be safe.
Hey, Judge, this is Sergio Davila, and let me know if you can hear me. I believe my witness is here.
Clause number 114333. Well, actually, the application for the approval of transfer of structured settlement annuity benefits. Who is your witness?
Mr. Saul Garza Jr.
Saul Garza Jr., are you present?
Yes, sir.
Okay, he is present in the hearing. Mr. Garza, please raise your right hand and be sworn. You swear testimony you're about to give here in this hearing will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Mr. Garza, you are not represented by an attorney. The attorney that is here, Mr. Zavi, that represents the buyers of your annuity or your structured settlement agreement. Do you understand that?
Yes, sir.
So he does not represent your interest, he represents theirs. Do you understand that?
Yes, sir.
Knowing that, do you still want to proceed today without the necessity of an attorney?
Yes, sir.
Very good. Mr. Zavi, you may proceed as nutshell version, sir.
That's over. Mr. Garza, can you state your full name for the court?
Saul Garza,
And you're a resident of Texas.
308 and Drive, Texas.
You are a resident of Texas?
Yes,
Okay. And you have an annuity owned by New York Life Insurance Company?
correct.
I'm sorry, excuse me, Mr. Davila, can you please speak up or look up to the microphone? I'm having trouble hearing you.
Let me switch microphones. Maybe that'd be best.
You're fine there.
Can you hear me better?
Much better
Can you hear me
there.
better? Okay.
She says yes. Just nodding her
you
head.
Okay. All right. Do you understand that today you're selling $100,000 out of that annuity to my client, Peachtree Settlement Funding?
Yes, sir.
Okay. And do you understand that specifically you're selling one payment in the amount of $100,000 that is due to you on December 7th, 2031? You're aware of that?
Yes.
And you understand that the discounted present value of that amount of money using the current federal discount rate is $88,316.
Mr. Davila, I can't, I'm sorry, Judge, if it's just me, but he's going in and out.
No, it's not just you. It's just that when he puts his head down the way he has it there, that's when we can't hear him. So you need to you need to just keep your head up, looking at the camera or something.
I have another headset I can try if that's a problem, but let me do that. It's a backup. It's the junior varsity headset. All right. All right. Can you hear me now?
Yes, we can hear you.
Okay, great. Okay, hopefully that's a better pickup. The amount promised to you in the future, the present value of that is $88,316.58. You understand that, Mr. Garza?
Yes.
Okay. And you understand that my client is going to be paying you a lump sum of $49,500, which is less than the $88,000 figure I just gave you?
Yes.
And you understand that if this had been a loan, the interest rate you'd be paying on that loan is 6.98%?
Yes.
And you understand that if this transaction is approved, that the lump sum $49,500 you will receive is the only money you'll ever receive for that payment that you're transferring out to my client today, right?
Yes.
And do you understand that if the judge approves this transaction, you cannot come back to him or this court or my client and undo the transaction, right?
Yes.
And you were advised to hire your own attorney
for any questions you might have about this transaction, right?
Yes.
And you understand that I'm here representing Peachtree Settlement Funding and I'm not representing you today, right?
Yes, sir.
And are you able to explain to the court the reason why you believe this transfer is in your best interest?
Yes, sir. Pay off some debt and getting a family vehicle.
Okay. And you don't have any other way to get that without this transfer, right?
Correct.
Okay. I don't have any questions for the witness anymore, Judge.
Thank you. Mr. Gatsa, you understand that, well, I already went over that with you. Thank you, sir. I'm gonna go ahead and find, and in fact, you understand the parameters of what this sale of the annuity is that you, in fact, are you representing yourself, that Mr. Davila represents the interest of the buyers of your structured settlement and annuity, and that you're aware of that, and despite that, you want to proceed in this manner. I make such finding and find that your sale is done freely and knowingly, and approve the sale of the structured settlement. Thank you, sir.
Thank you, sir.
I'll sign off on that as well. Thank you.
Thank you, Judge. I appreciate the indulgence and the accommodation. If I may be excused.
Thank you, sir. Yes, of course.
Have a great day. Bye-bye.
Marcel Nata.
Thank you, Judge. Just a 30-second announcement. My client Cynthia Guerra's here. I don't believe there's anyone here for Carlos Bonilla or Mayra Alicia Gonzalez. If we can verify that, Judge.
Juan Carlos Bonilla, Mayra Alicia Gonzalez, are you present? Anybody present on their behalf? You may proceed.
Yes, Judge. We're set for final pretrial today. We're set for trial on September 13th. We're going to be requesting a bench trial. It'll be 15, 20 minutes max. We already have a partial summary judgment on liability and the medical records, which we had proved up previously. We have an order from the court on that already. So it's just on my client's physical pain and suffering. She had about 120 in medical.
Hold on, Mr. Johnson. So you're going to do that then, or you're going to do it now?
I mean, if you want, I can do it now, or if you think it's better to do it on the 13th, I can do it on the 13th, Judge, and streamline it.
You basically told me that you had a bench trial set for the 13th and that you were going to present this evidence then.
Yes.
What do you have set for today?
Just final pretrial, Judge.
Then we don't present it today. We have to present it then.
Okay, that's fine, Judge.
So come back with your, I guess if you're going to have any exhibits, have them ready.
Yeah, I'll have them ready, Your Honor.
We'll do it at that point. I don't expect anybody to show up at that point from the defense side.
Okay, and it's just for my client, September 13th at 8:30. So
sure,
we'll see you then, Judge. Thank you. May I be excused?
Yes, sir, of course.
Have a great day. Oh, I did have one other one. Just a quick announcement. Rene Guerra, 11-455. That was removed to federal court. So that's a quick announcement.
Thank you, sir.
Thank you, Judge.
I got that one done. Okay. Maddox, I see you there. I'm trying to get to like in the next 5 to 10 minutes max. Okay, Miss Maddox and Miss
Okay.
who else was there? Oh, Miss Sierra. 5 to 10 minutes. I'll be right with you.
Thank you, Judge. Thank
We had Ricky Solis. We have that one. Mr. Chu for Irma Lytle or Little. Nathan Chu, be present. No. Going once. Irma Little or Irma Lytle?
This is Eric Little, Your Honor.
There you go. I'm sorry. It says Irma there.
Yes, my wife is here, but she just stepped out of the room for a second.
Oh, I'm sorry. That's your wife. Okay. So is Mr. Chu representing you all?
Yes, sir, he is.
Okay. So we don't see him here anymore.
He's there, Judge. He cannot unmute himself. That's what he put in the chat.
Oh. Okay. Yeah, that's not good. Mr. Yu is trying to unmute himself, Mr. Little, so we're gonna go to the next one until Mr. Chu is able to do that, because I got, okay, I'll be right with you. Roshan Phipps? Or Roshan Phipps? You might want to change devices, Mr. Chu. See if you can get to it. Mr. Oh, did we lose him?
What happened? He left.
Miss all right, Miss Little is still there. Okay, so there is no Roshan Phipps. Okay, we're gonna skip that for now. So, Mr. Figueroa, you have a whole bunch of announcements.
Yes, Your Honor. Present and ready, Your Honor. You want me to call them out, Judge?
Well, if they're in order, otherwise I'll call them out. 11?
Okay, it's 11-217 is the first one, Your Honor.
All right, what is your announcement?
Judge, Your Honor granted the default on July 19th, but you set a motion for entry of judgment. We have submitted the judgment for the court's consideration, Your Honor.
All right, I'll sign off on that.
Thank you, Your Honor.
11-254.
264, Your Honor?
54, yes.
Okay, Judge, we have a citation by posting return on 7/12/21. Judge, we are requesting a default judgment be granted on this matter. We ask the court take judicial notice of the case file, indicate service has been effectuated in accordance with the law. We have a motion and judgment submitted for the court's consideration.
The court take judicial notice as requested, and default judgment is granted.
Thank you, Your Honor.
Did you submit that order at judgment?
Yes, Your Honor.
All right. 11-270. State versus 2000-787.
Yes, Your Honor. Your Honor granted a default on this on July 19th, 2021, but was scheduled for submission of order that has subsequently been submitted, Your Honor.
Thank you. I'll sign off on the judgment.
Thank you, Judge.
7301, State versus 2001 Chevrolet.
We had a citation by posting return on 7/12/21, Judge. We are requesting default judgment. We ask the court take judicial notice of the case file. Motion and judgment has been submitted for the court's consideration.
I'll sign off on that judgment as well.
Thank you, Your Honor.
11307, State versus 2005 Dodge Durango.
Yes, Your Honor. A citation by posting was returned 7/12/21. We are requesting a default judgment. We ask the court take judicial notice of the case file, which indicates service has been effectuated in accordance with the law. And we have a motion and judgment for the court's consideration has been submitted to Your Honor.
Leticia Hinojosa, are you present in the hearing? The court take judicial notice of the entire file, the fact that Ms. Hinojosa was served back on July 12th. There is no answer. No one is present. Default judgment is granted. Let's see, 11-337, is it? Yes, State versus 1006-24.
Judge, we received a letter on the July 9th, Judge, from a Andres Perez, but I'm not certain if he showed up or not, Your Honor.
He's
In custody, Mr.
Judge.
Figueroa.
He's right there.
Okay. Okay, Judge, we will, I have not had a chance to discuss this specific matter with him, Judge. I guess that's because he's in custody, Your Honor, but.
All right, I want to set him for October 22nd on this issue at 1:30. See if you can,
I'll reach out to him, Your Honor.
Right, thank you. Thank you, Mr. Martinez.
Okay.
11339, State versus
Yes.
2005 Nissan.
Yes, Your Honor.
On July 13th.
Yes, Your Honor. In this particular matter, citation by posting was returned on July 14th, 2021. We're requesting a default judgment. Ask Your Honor to take judicial notice of the case file. We have a motion and judgment submitted to your honor for your honor's consideration.
The court takes judicial notice of the entire file. The fact that no one has filed an answer, that will be served, and the default judgment is granted. 11-340, State versus 2007 Chevrolet.
Judge, we're requesting a reset on this matter, Judge. We still need to submit a citation by posting, your honor, so we're requesting.
October the 22nd, then at 1:30.
Thank you, your honor.
11,384, State versus $560, and $44,900 in Mexican currency, 44,900 pesos, I guess I'd say.
That's correct, your honor. We are requesting a reset on this matter, Judge, so we can submit, or we've submitted to your honor a motion for substitute service and requesting the time to be able to effectuate that, your honor.
I'm gonna give you November 1st at 1:30.
November 1st, thank you, your honor.
11,404, State versus 2013 GMC Terrain.
Yes, your honor. We have a return receipt on the service on 6/21 of this year, your honor. We're requesting a default judgment. Ask your honor to take judicial notice of the case file and we have a motion of judgment for your honor's consideration.
Court take judicial notice of the entire file. There is no one here responding to this. It's been served. Judgment, the default judgment will be granted.
Thank you, your honor.
2014 Buick Veran, that's 11,407.
Yes, your honor. We have a receipt returned on June 19th, 2021. We're submitting a motion for default judgment for your honor's consideration. Plus, we asked the court to take judicial notice of the case file, which will indicate service has been effectuated in accordance with the law.
The court take judicial notice of the entire file. The fact that the respondent was served, there was no answer, and then no one is present here today. The judgment of default is granted. State versus 2020 Nissan Kicks.
Your honor, on this one, I believe there is an answer that has been filed by Mr. Al Green, who's assisting Miss Samantha Green in the matter. He said he was going to provide some exculpatory evidence to my office. I have not received it as of yet, but I have no objection to passing the case for the October 22nd setting, if your honor is
We have
agreeable.
no answer on file.
Oh, we don't have an answer. Okay, well,
No,
I guess he just told me personally.
We'll set it for October 22nd. You can work it out with them.
Thank you, your honor.
State versus $1,662.
Your honor. Oh, sorry.
Go ahead.
Judge, this was served on July 15th, 2021. We're requesting a default judgment. We ask the court to take judicial notice of the case file, which indicates service has been effectuated in accordance with the law. We have a motion of judgment that's submitted to your office, your honor, and we ask that you grant this motion.
Thank you, sir. Be granted. We'll take this notice of the entire file. Make its findings and grant you a default. Okay, thank you, Mr. Filo.
Thank you, Judge. The quantities are a little bit higher now, Judge. I hope more worthy of your honor's time.
I was concerned worthy of your time, much less than mine, but
yeah, Judge, times were a little bit lean for a while that we were filing on $50 and $60, but now it's getting much better, your honor. Thank you very much. If I may be excused, your honor.
Excuse. Mr. Chu, unmute yourself, sir. Nathan Chu. Nathan Chu. Oh my God. Nathan Chu.
Judge, it's working.
It's working. So you're here on the little case.
Yes, sir. The parties have been served. Judge, the parties have been served. I'll probably just, I think I will file a pretrial guideline order, and I'll probably just have to file a default judgment soon if they haven't responded, Judge.
Okay. Then file a guideline order. Do you want to file it by September 5th? When did you serve them?
I think we served them about 3
July
weeks ago,
19, Judge.
Okay. Well, this was the calendar call today, but I mean, I can give you the I mean, I have a hearing September 15th, and then I have one on October 22nd.
I think September 15th should be fine, Judge. That way I can put in my motion for default.
All right, do it then. Thank you.
Thank you, Your Honor.
At 1:30.
Thank you, Judge.
Thank you. Okay, Ms. Maddox. And Ms. Cigarra.
Good afternoon, Your Honor. We're
Hi, Judge.
set in cause number 11,289 on Ms. Cigarroa's motion for summary, traditional motion for summary judgment. And I believe our clients are present and in the courtroom.
All right.
Good afternoon, Your Honor. Martha Cigarro on behalf of Walter Smith, who is here.
Okay, so tell me again the cause number.
11-289, in the interest of KMS, a child.
11-289.
Yes, sir.
Where's that? Was that from the morning?
Yes, sir, it is.
That's right. It was from the morning.
Early morning.
Yeah. In the interest of KMS a child. Okay, so here we go.
Yes, Your Honor. Again, may it please the court, Ms. Maddox and Mr. Smith. Martha Cigarro on behalf of the movement for Walter Smith. Just for background, Your Honor, this is a case that Mr. and Mrs. Smith were divorced in B County on October 13th of 2015. The case was transferred to this court in Zapata County in January of this year. My client, Mr. Smith, is the adjudicated father of the child, and Ms. Maddox's client intervened in this suit after several hearings were held in this case. The court may also recall that my client is the primary possessor of the child and has had continuous access, possession, and custody of the child since the child was born. The motion for summary judgment is a very simple, straightforward motion, and it invokes, Your Honor, as the court may recall at the last hearings, we talked about section 160.609B of the Texas Family Code that provides that in an instance like this, when the child, Kaylee, has an adjudicated father, an individual like Mr. Galvan in this case, who seeks to adjudicate the paternity of the child, must commence a proceeding not later than the 4th anniversary of the date of the acknowledgement or adjudication. In this case, the day one in this case is October 13, 2015. I would ask the court to take judicial notice of the fact that the intervention was not filed until March of this year, almost 6 years, Your Honor, and that was March 31, almost 6 years from the date that the decree was entered. Therefore, we ask that the court grant the summary judgment because the intervener is time barred by that specific statutory section that I advised the court, that being 160.609B of the Texas Family Code.
Okay.
And Your Honor, that's all I have on my motion. However, I do have some substantial objections to Ms. Maddox's or Mr. Galvan's evidence and argument.
I would object to any untimely objections to my evidence, Judge, because as this court knows, they must be in writing and filed with the court, and I have not been served with any of those.
The objection is
May
in writing. It was filed almost immediately after you filed the intervention, and the objection is that to the specific attempt to introduce summary judgment evidence, and that is absolutely on file. And if I don't know how, I don't mean to step on your toes, Ms. Maddox, but I do want the court to know that I have two substantive objections that I think are controlling in this case. I have another objection. I don't know when the court wants me to urge that.
If I could just know when those were served on me, because I haven't
The
received them.
objection to the purported DNA result was filed on April the 6th of 2021. And you were served on April the 6th of 2021. And that document was accepted through e-filing by Dora Castañón of the District Clerk in Zapata County, Texas. That's been on file.
But that's not part of the motion for summary judgment, Judge. That's not part of the motion for
No,
summary
it's an
judgment. If
objection.
it was filed,
It's an
if it was
objection
filed
to
in,
your evidence. It's
right,
an objection.
but my evidence wasn't filed until 7 days ago, Judge. And so any objections should have been filed after my evidence was made. So if I could just reply to or respond. So what we filed, Judge, I don't believe that Mr. Smith can reach the heavy burden of seeking a traditional summary judgment in this case, because the Texas Supreme Court has long established that fraud prevents the running of the statute of limitations until it's discovered, or by the exercise of reasonable diligence by when it could have been discovered. The court, and I cited Hooks v. Sampson, 457 Southwest 3rd, 52, and the court has recognized that fraud vitiates whatever it touches, and a wrongdoer cannot take advantage of a statute of limitations by any deceitful concealment, and reasonable diligence is ordinarily a question of fact, and that's what we have here. Mr. Smith made affirmative, material, false representations to the biological mother of this child about his paternity of this child. He specifically asserted that he and the child had undergone a genetic paternity test at a medical clinic in Beeville, Texas. He made these affirmative claims to the biological mother of the child. She then shared this information with the true biological father of the child. She believed her husband when he told her that he was the biological father of the child because he had taken a paternity test to prove so. When my client found out about this fraud, he exercised diligence and had his own biological and genetic tests done. And therefore, the fraud conducted by Mr. Smith tolls the statute of limitations, because but for his fraud and misrepresentations to Miss Smith, he would not have been adjudicated as the father of the child. And why would anybody, nobody could ever fathom that a person would lie and commit fraud about being the biological parent of a child.
So that the summary judgment evidence to that effect is the statement by the former Miss Smith?
The statement by my client that
No, the summary judgment evidence of Mr. Is it Smith?
Yes,
Of Mr.
he's a
Smith's
party.
fraud was made to who, and how does it appear on the summary judgment evidence?
He made that representation to Enedina Smith, the biological mother of the child. And those are parties. They are all parties to this
I understand,
case.
but do you have a statement from her or a deposition, or what is it? How does it appear in terms of summary judgment evidence?
We attached her affidavit, Judge, as a part of our summary judgment evidence. Our summary judgment evidence includes the genetic test showing that my client.
Can you give me the exhibit of her affidavit? I'm sorry.
Yes, Your Honor. That's okay. It's within my motion. So the Exhibit A is the genetic test results. Exhibit B is the declaration of my client, Jose Galvan, and Exhibit C is the declaration of Enedina.
Okay.
Galvan Nee Smith.
So Enedina's on C.
Yes.
Smith. Okay.
And what she says in her declaration is that she had previously been in a relationship with Mr. Galvan, that she and Mr. Smith divorced, and Walter Smith told her he was taking the child to get a DNA test at a medical clinic in Beeville, Texas, where he lived. Walter Smith later told her that the results of the paternity test confirmed that he was the biological father of the child, and Enedina believed him. Years later, she reconciled with Jesus Galvan and relayed those statements to my client, Mr. Galvan. And then later in 2020, it was in August of 2020, Walter's girlfriend, Casey Hensley, dropped off the child. My client noticed a remarkable resemblance, and Miss Hensley, Walter's girlfriend, also told Miss Smith, he's not the biological father of the child. I found a test that shows he's not. And so upon this revelation, my client used his diligence and went and had a paternity test done. So, but for the fraud, and that's a fact issue, Judge. And therefore, Mr. Smith cannot succeed in his motion for summary judgment.
May I respond, Your Honor?
Yes, of course.
First of all, Your Honor, the objection, which does not need to be in writing, the further objection to the theory, this novel theory that we have now received, is that there's no pleading in the intervention alleging fraud. That is something that now they've brought in at this late stage, but there is no pleading, number one. Number two, Your Honor, to do the mental gymnastics that Miss Galvan want, Mr. and Mrs. Galvan, because they're now married apparently, to do the mental gymnastics that they want you to do, let's follow the real facts here. And those are not even in summary judgment. It's not necessary. There are only two people on this earth who know and have personal knowledge about whether or not they had a sexual tryst in order to have a child. And guess what? That could not include my client. That is only Mr. Galvan and Mrs. Galvan, the other two parties in this case.
What do you mean by that?
Sure. They're the ones that know whether or not they had sexual intercourse and when.
But what does that matter?
Because if he's now claiming to be the biological father almost 6 years later, he knew and should have known that this child was born. He's known that for a long time. And excuse me, let me finish.
I have an objection because she's arguing outside of the motion for summary judgment evidence, and therefore there's nothing in her motion or there's nothing in the form of a reply that goes to this judge. And so the court is limited to the motion for the motion for summary judgment evidence that was on file 21 days before the hearing and 7 days before the hearing.
I don't think she's arguing the fact. She's arguing just what what follows. I mean, she doesn't need to have any facts to say, hey, when two people have sex, they know that there is a chance that you might get pregnant. But you're saying because they had sex, then and she got pregnant in and around that time, then that places him on notice that he could be the father. Isn't that then, assuming that what they're saying is true, doesn't that get trumped by the fact that somebody says, I was having sex with her too, and here is the results of my DNA. Therefore, boom, in other words, isn't it like saying, I'm going to go call the ambulance, and then somebody, no, it's okay, I already called it, right? And then you don't go call the ambulance because somebody already assured you that they called the ambulance.
No, Your Honor, respectfully, I completely disagree with that. He knew or should have known, and certainly.
How did he know? How did he should have known?
He had sex with her.
Yeah, but that doesn't mean you're the father.
No, but he had knowledge then that he needed to be more proactive. Showing up now 6 years later.
No, but what about when somebody says he just went to go get tested, he's not yours? In other words, I'm just saying if it was true.
He has it. The burden is not on my client who was not a participant to that act. See, they're
He was
trying
a
to shift.
participant. He's a participant according to the summary judgment to the statement.
But Your Honor, you can absolutely disregard both of those statements because they are both parties. You must, Your Honor, use your common sense.
But they're regardless of whether they're true or not, they're still injected facts into the summary judgment.
No, Your Honor,
Now we either have to choose. Isn't somebody given the opportunity to either believe or not believe that?
And yes, and it's not a material fact because in this case, my client could not have defrauded either of them because number one, they don't have pleadings to that. But number two, they are the only personal actors, not my client.
I object to that statement because I have a pleading that was filed on August 23rd that pleads affirmative defenses are barred by fraud, fraudulent concealment, estoppel, and unclean hands. So we absolutely have a pleading that is on file in that regard, Judge.
Okay, well, I was referring to the pleading that you filed on
right. The original pleading, but there was a supplemental pleading filed.
Okay, I have what is called the amended petition and intervention. I don't know what you're referring to.
Okay, thank you. Go ahead, proceed then.
So my client cannot possibly defraud. Certainly, if he has a complaint, the complaint should be with mom, not with my client. My client was not an actor. He certainly knew or should have known, and she certainly knew and should have known that he had to go forward at any time to get this DNA test. Waiting more than 4 years from the date that my client was the adjudicated parent is outside of the limitations. You cannot come to this court with unclean hands because he had personal knowledge. There's only 2 people that had that personal knowledge, and it was Mr. and Mrs. Galvan.
And I disagree with that, Judge, because if Walter Smith also engaged in sexual relations with Enedina Galvan Nee Smith, then it's reasonable for them to believe Mr. Smith's fraud and misleading statements, claiming that he actually took a biological test to prove that he was the father of the child. And that's the only way that he could have become the adjudicated father, because Mr. Galvan and Ms. Smith believed him and relied on his false statements.
Your Honor, that really makes no sense. They each have a duty.
But isn't it even worse because supposedly, according to what Miss
Maddox
Benavides Maddox said was that the girlfriend or the ex-girlfriend, whatever it is, said that she found the lab test and that it showed that it was negative.
But Your Honor, the problem with that circular reasoning and that you have to do a lot of mental gymnastics to get to where they want you to go. I'm trying to take you to the very beginning, which is the only 2 people who have any factual and personal knowledge about that sexual tryst. And what I'm saying is that's when he knew or should have known that he had a duty to go forward and find out. These people have had a relationship this entire time.
And that's not the basis of her motion for summary judgment. Her basis for the motion of summary judgment is, as a matter of law, he is the adjudicated father. And my opposition to that is, well, there is a fact question. And that fact question arises because of Mr. Smith's fraud. And therefore, the motion should be denied because the logic does not say that Mr. Galvan can be the only biological father of the child. And so when Mrs. Enedina Smith said, Walter Smith told me he's the biological father, and I believe him, and my client relies on those statements, that raises a fact issue, Judge.
But Your Honor,
And so whether,
that's
whether the fraud,
absolutely shifting the burden. You're
Wait,
putting
one-
the
one at a
burden on
time.
my client. I'm sorry, I didn't, Ms. Maddox, I'm sorry, I thought you were done. My bad.
it's not shifting the burden, Judge, it's raising a fact issue. And that's why the motion should be denied.
Your Honor, these are adults. They are the only two people that have any personal knowledge of what they did 9 months before this child was born. To make
Exactly.
yeah, and because they're the only
Exactly.
two, not my client.
Okay, let me just say something. Are you
So
saying?
if she
Wait.
also had sex with Walter Smith, then she could reasonably believe that he was the biological father.
No. If a person is having sex with two different people in and around the same time, that woman is not going to know whether or not it's one person or the others. There is no question. I mean, well, this is me saying, it's logical to imagine that if they're having sex with multiple partners during the same period of time, let's say within a week or 7 days of each other or whatever, 10 days, whatever it may be, that you're not going to be able to pinpoint it directly at that day. I mean, I've seen some people that have gone to the Attorney General's office, Child Support Division, with 3 or 4 different potential fathers, and they take a blood test. Nope, this one's not it. Come to the next one. Nope, this one wasn't it. Come to the next one. You know, that type of thing. It's unfortunate, but you know that happens to people. It does happen to people. So it's logical to assume that could potentially have happened.
But Your Honor, what?
But I see what you're saying. You're saying is you had sex.
Yeah.
You got pregnant. You could have thought it. So one of the questions that you could have thought that Mr. Galvan would have said to her was, because she was married at the time, right? Right? She was married to Mr. Smith at the time?
Yes, Your Honor.
Okay. So she could have said, Mr. Galvan was over here thinking, gee, she's pregnant. I wonder if it's mine. And then she's like, and then thinking, and then she comes back and says, Miss Maddox says, no, but then she comes back and says, no, he's not yours, because Mr. Smith already took him and he checked him out and he got the blood results and it's his. And the guy goes, whoosh, like that.
But under that theory, Your Honor, pardon me, under that theory, again, he's the responsible adult and she's the responsible adult. There was nothing that he said at that time to stop him from doing anything. The night after he had sex with her and he knew that she had the baby 9 months later, he had a duty. It was nothing that my client could have done or not done. He had a duty, and under their theory, my client has no personal knowledge of that. Zero.
I guess what Miss Maddox is basically saying is the equivalent of, he was about to call the ambulance, but Mr. Smith said he called the ambulance.
Actually, Your Honor, there's a different way of
reasonable.
Yeah.
He used reasonable diligence. He relied on Walter Smith's statements and he relied on Enedina Smith's statements.
Let me ask you a question about that, Miss Tierra. If the fraud was committed by mom instead of Mr. Smith, isn't he still protected by that?
No, Your Honor, because the date, because the statute is very clear that it's the date that my client became the adjudicated father. It's 4 years. None of this.
No, but the fraud, if there was a fraud committed on him, could the fraud have been committed by mom just as much as dad, is my question.
I don't know, but under my theory, no, because Mr. Galvan has an affirmative duty to secure his rights to the child.
Check it out. We got it.
He doesn't have that's not what the statute says under the statute of limitations. It says he has four years from when he finds out, and that statute is told by fraud, and we have evidence of fraud. Therefore, we have a fact issue.
Thank you. I got the picture. I will. Did y'all submit your judgments?
No, Your Honor, but we do need it. We do need a ruling because obviously
the ruling on your objections, it will be denied, and then I will give you my ruling. You know, I just need to look. I'm going to review that section of the code and any annotations to it, and then I will give you my ruling.
The reason, Your Honor, that we do need a ruling is because unfortunately the child has been told that my client is not his father. despite the fact that the court has ordered that not occur. And the longer that this is delayed, the worse it is on the child and on my client. And this would be a travesty, Your Honor, a real
I'll
travesty.
object to, I object to the hearsay.
Thank you all.
Thank you, Judge.
Thank you, Judge.
Noemi, make sure that you send me an email on this case, please, with regard to ruling.
Yes, Judge.
Thank
Your Honor,
you.
may we be excused?
You are excused. Thank you.
Thank you, Judge.
Okay, let's go back up to the gallery and see what's left. Okay. Let's check from the morning docket, the family. Last time that we called this case, it did not appear. 7004 in the interest of Mac, a child. This one we come from William John Cisneros, Joanne Gonzalez. Anybody here on that case? Remember, they didn't appear last time either. William John Cisneros, Joanne Gonzalez. Nope. This case will be dismissed for want of prosecution. In the interest of VC, RC, and AC children, we did that one. What about page 3? In the interest of Faith Elaine Barragan, did we do that one? Oh, Flor Flores.
She submitted the order, Judge.
Submitted the order. Okay, thank you. We're going to page 5. In the interest of marriage of Olga Ibarra and George Garcilaso. Pro se. Olga Ibarra, George Garcilaso, are you there?
Aquí estoy, sir.
Ándale.
Olga Ibarra.
Okay.
I'm here, sir. Olga Ibarra.
Service was effectuated August 2nd. I think we do have time already. Is there any answer by George Garcilaso?
No, Judge.
There is no answer. Is there a George Garcilaso here in the hearing? No, he's not. Okay, Ms. Ibarra, please raise your right hand and be sworn.
Señora Ibarra, por favor, levante su mano derecha para prestar juramento.
Claro.
You swear testimony you're about to give here in the trial be the truth, the whole truth, and nothing but the truth, so help you God.
¿Usted jura que la declaración que va a dar en este momento es la verdad, toda la verdad y nada más que la verdad, con el amparo de Dios? I swear.
Okay. Do you have any children
No.
born of this marriage? There are none.
No.
Was there a child born during the marriage? Was there a child born from you during the marriage?
¿Usted tuvo un niño durante este matrimonio?
No.
¿Un menor? No.
No.
Okay. Did you and Mr. Mr. Garcilaso accumulate any property?
¿Usted y el señor Garcilaso acumularon alguna propiedad o inmueble?
No, no.
No.
How long were you married?
¿Cuánto tiempo estuvieron casados?
Pues de que nos casamos a que nos separamos como 2 años.
Well, since we got married to the time we got separated, about 2 years.
Did you and Mr. Garcilaso already have your own things, your own house, your own car before you got married?
Cuando ustedes se casaron, ustedes ya tenían sus propias cosas, su propia casa y sus propios automóviles.
Sí, yo traía mi carro, él traía su troca y rentábamos. No teníamos casa.
Okay.
Yes, so I had my car, he had his truck, and we rented. We didn't have a house.
All right. So when you separated, you already kept your things and he already took his things?
Entonces, cuando se separaron, usted se quedó con sus pertenencias y él se llevó las de él?
Sí.
Yes.
There is nothing that he has that belongs to you or that you have that belongs to him?
¿Y no hay nada que él tenga que le pertenezca a usted o que usted tenga que le pertenezca a él?
No.
No.
Very well. The court will find that each party will keep the property that they have in their personal possession and control, and all bank accounts and cash in their own name and control, and all the vehicles possession and control as well.
Muy bien, entonces es decisión que cada uno se va a quedar con sus propiedades, sus pertenencias que ya tienen bajo su posesión y control, al igual con todas las cuentas de banco y cualquier dinero que tengan al contado, incluyendo todos los vehículos que ya tengan en su posesión.
In terms of the debt, do you want to be able to keep your debt under your name and him to keep the debt under his name?
En lo que tiene que ver con la deuda, usted está pidiendo que se le dé a usted las deudas que tiene bajo su nombre y las deudas de él que se queden bajo el nombre de él.
Sí, sí.
Yes.
Somos separado todo.
Yes, everything separate.
Very well.
Muy bien.
You're asking for this divorce because your marriage has become insupportable as a result of conflict of personalities and there is no expectation of reconciliation?
Usted está pidiendo este divorcio por la situación insostenible, por incompatibilidad de caracteres en este momento.
Sí.
Yes.
Very well. Then your divorce will be granted in the manner which you have requested, and the decree of divorce that you have submitted has been signed. It will reflect your testimony here today.
Muy bien, entonces su divorcio ha sido concedido y ha sido firmado como me lo han tramitado el día de hoy.
Thank you, ma'am.
Muchas gracias.
Gracias.
Thank you.
Talk to you, ma'am. Patricia Muñoz and Luis Abraham Paredes, 11381. There is a waiver on file. Patricia Muñoz is present. There is a waiver on file. Ms. Muñoz, unmute yourself, ma'am.
Sí, presente. Presente.
Yes, present.
Very well. You are asking for this divorce, Ms. Muñoz?
Señora Muñoz, ¿en este momento usted está pidiendo por este divorcio?
Sí.
Yes.
Okay, Ms. Muñoz, please raise your right hand and be sworn.
Por favor, se levante su mano derecha para prestar juramento.
You swear testimony you're about to give here in this trial be the truth, the whole truth, nothing but the truth, so help you God?
¿Usted jura que la declaración que va a dar en este momento es la verdad, toda la verdad y nada más que la verdad con el amparo de Dios?
Sí.
Yes.
Very well, ma'am. Did you and Mr. Paredes have any children born of the marriage?
¿Usted y el señor Paredes tuvieron un bebé de este matrimonio?
No.
No.
Very well. You're asking that I approve the divorce decree that you have submitted to me?
¿Usted está pidiendo que yo apruebe este divorcio, el decreto del divorcio que usted me ha tramitado el día de hoy?
Sí.
Yes.
How long were you and Mr. Paredes married?
¿Cuánto tiempo duraron de casados usted y el señor Paredes?
1 año 9 meses.
1 year and 9 months.
During that time, did you all accumulate any property together?
¿Durante este tiempo ustedes acumularon algún inmueble?
No.
No.
When you got married, did you already have your things and he already had things, his things like cars and a house maybe or anything like that?
Cuando ustedes se casaron, ustedes ya tenían sus propias pertenencias, usted tenía las de usted y él tenía las de él como un vehículo.
Sí.
Yes.
Did you have a car, ma'am, or did you have a house?
I'm sorry, Your Honor, you cut off. May you repeat?
What things did you already have when you got married, at the time you got married?
Cuando usted se casó, ¿usted qué pertenencias tenía usted?
No, pues nada más la casa en México que es de mis hijos.
Well, just the house that I had in Mexico that belongs to my children.
And what city is it located in so I can make sure that it's your separate property?
¿Y en qué ciudad está para asegurarme de que esta propiedad sea separada para usted?
Camargo, Tamaulipas.
San Marco, Tamaulipas.
Very well. When you all separated, did you all both keep the things that your personal things in that you have under your possession and control?
Cuando ustedes se separaron, cada uno se quedó con sus pertenencias personales.
Sí.
Yes.
Is that the way you want me to award them to whoever has the things in their possession and control? It's going to be awarded to them?
¿Y usted quiere que yo lo otorgue de esta manera a cualquier persona que ya tenga sus pertenencias consigo, que se queden con él o ella?
Sí.
Yes.
Very well. What about the debts? You want to have the debts that you have under your name and he keeps the debts under his name?
Y con lo que tiene que ver con la deuda, ¿usted quiere quedarse con las deudas que estén bajo su nombre y que él se quede con las deudas de él que están bajo el nombre de él?
Sí.
Yes.
Very well. Then I am going to authorize this divorce. I'm going to find that your divorce is made freely and that you make it knowingly and that you are asking the divorce for the divorce is granted for the reason that you seek it here today.
Muy bien, entonces en este momento voy a autorizar este divorcio. Usted está haciendo esta decisión libremente y a sabiendas y lo estoy firmando como me lo han tramitado el día de hoy.
Ok, nada más quiero decirle una cosa. El nombre que en la carta que me mandaron dice Luis Abraham y es Abraham con N.
Yes, just one thing. On the letter that they sent me, it said Luis Abraham, but his is Abraham with an N.
Así, well, it's with an N. Thank you, ma'am.
Muy bien,
Okay.
haremos ese cambio. Gracias.
Gracias.
Thank you.
Suerte, mucha suerte.
Good luck.
In the matter of the marriage of Domingo Reyes and Yesenia Canales.
Yes, sir.
Aquí estoy, señor juez.
I'm here, Judge.
Okay. And Domingo Reyes is also present.
Yes, sir.
There you are. Okay, both of you, please raise your right hand and be sworn.
Muy bien, los dos, por favor, levanten la mano derecha para prestar juramento.
Do you swear testimony you're about to give here in this trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Ustedes juran en este momento, declaran decir la declaración que harán en este momento va a ser la verdad, toda la verdad y nada más que la verdad con el amparo de Dios.
Sí.
Yes.
All right. Mr. Reyes, you can put your hand on it. You are seeking this divorce from Yesenia Canales here today, is that correct?
Yes, sir. Just wanted
Hold on. Let me just answer my question, sir, real quick.
All
At
right.
the end, I'll ask you if you want anything else.
Yes, sir.
Muy bien, señor Reyes, en este momento usted está pidiendo.
We also have to interpret, so you got to pause for that.
Muy bien, señor Reyes, usted está pidiendo el divorcio de la señora Canales el día de hoy. Sí.
Yes, sir. Sí.
No, not for you. The interpreter is going to be interpreting for her because she doesn't understand English.
All right.
Okay. Are you okay? So you answer my questions in English. She'll take care of doing that in Spanish. Okay.
Yes, sir.
All right. Now, Mr. Reyes, you and Ms. Canales were married when?
¿Cuándo se casaron usted y la señora Canales, señor Reyes?
I don't remember. It was almost a year ago. I'm not
a big on the date.
No, sir.
Okay.
And
No
that's very,
recuerdo. No recuerdo, fue hace como un año.
All right. So during that time that you were married to her, did you all have any children together?
no, sir.
Bueno, durante este tiempo que estuvieron casados, ¿ustedes tuvieron algún bebé? No, su señoría.
Did Ms. Canales have any children?
¿Y la señora Canales tenía niños?
Yes, she had her own kids.
Sí, ella tenía sus hijos.
Right, but she didn't have any children born while you were married.
No, sir.
No, pero ella no tuvo ningún bebé que haya nacido durante este matrimonio. No, su señoría.
All right. So, when you came into the marriage, how old are you now?
I'm 36.
¿Qué edad tiene? Tengo 36 años.
When you came into the marriage, you already had certain things with you, and she already had certain things with her, yes?
Yes, sir.
Y cuando ustedes se casaron, ustedes cada uno ya tenía sus propias cosas y pertenencias, ¿correcto? Sí.
And so today, now that you're getting divorced, I ask you this. During the marriage, did you all accumulate anything more than you already had?
She had a car. I paid it off, and then I bought a vehicle under, my name. I put it under my name, paid her vehicle off, and helped her out, in the household and here and there, But that's it, Paid her bills, paid her bills, took her out of work.
Hold on. Hold on. We got to get the interpreter in.
El día de hoy, ahora que están pidiendo este divorcio, ¿hay algunas propiedades o muebles o pertenencias que acumularon durante este matrimonio? Bueno, sí, cuando nos estuvimos casados y le compramos un automóvil a ella y ya se lo pagué. También me compré un carro para mí que está bajo mi nombre, también lo pagué y yo le ayudaba a ella a pagar los biles, le pagaba todos los biles.
Okay. So here today, you're seeking to have the 2012 Dodge Challenger awarded to you, the 2015 Chevrolet Impala awarded to you, and all your tools belonging to that you have in the barbecue pit that's also there. Did you already pick all that up?
No, I just want that that 2012 Dodge and that Impala. I don't want it. She can keep it. And my tools and my barbecue pit. She hasn't let me get nothing out of there.
Okay, hold on. Go ahead.
Bueno, entonces el día de hoy me estás pidiendo que tú te quieres quedar con el Dodge Challenger del año 2012, el Impala Chevy, tus herramientas y el asadero, ¿correcto? Yo me quiero quedar con el Dodge Challenger, pero ella se puede quedar con el Impala. También quiero mis herramientas y el asadero. Desde que me separé no me han dejado entrar a la casa.
Okay. And you want her to keep the 2014 Chevy Malibu.
Yes, sir.
Okay.
¿Y quieres que ella se quede con el Chevy Malibu 2014? Sí.
Anything else other than those things that needs to be exchanged?
¿Hay algo más aparte de esas cosas que se tengan que intercambiar? Nada más.
When would you like to pick up your tools and barbecue pit?
As soon as possible. I can be there tomorrow or day after tomorrow.
Where does she live?
Zapata at 2009 Jackson Street.
Okay.
Muy bien, ¿y cuándo quieres recoger tus herramientas y el asadero? Lo más pronto posible. ¿Podría ir mañana o pasado mañana? ¿Y dónde vive ella? En Zapata, en 2009 Jackson, en la calle Jackson.
Okay. You are seeking this divorce, Mr. Reyes, because your marriage has become insupportable as a result of conflict of personality between you and Ms. Canales, and there is no expectation that you can actually reconcile.
Yes, sir.
Very good.
Entonces usted está pidiendo este divorcio por la situación insostenible y la incompatibilidad de caracteres entre usted y la señora Canales y no hay ninguna expectativa de reconciliación. No, su señoría.
Ms. Canales, now you.
Ande.
Ahora con usted, señora Canales. Yes, sir.
Mr. Reyes wants to be able to get awarded the 2012 Dodge, and he wants to pick up all of his tools and his belongings and his barbecue pit.
Señora, el señor Reyes también quiere quedarse con el 2012 Dodge, sus herramientas, sus pertenencias y el asadero.
Where are the tools at? Do you have control over the tools and the barbecue pit?
¿Dónde están las herramientas y el asadero? ¿Usted tiene control de estas?
Eso está aquí, pero todo se compró dentro del matrimonio. Mi casa ya la tenía, mi carro, mis dos carros también. Nomás me alcanzó a pagar del Impala como 1,500, de 1,500 a $2,000. Pero yo tengo pruebas de que esos carros se sacaron yo los compré sola, junto con mi casa. El asador se compró dentro del matrimonio. Y todo lo que quiere él, la herramienta sí es de él. El asador.
Wait.
Dame un segundo.
Wait.
Yes, they're here, but they were purchased during the marriage. I bought my house. I had my two cars. He helped me with the Impala between $1,500 and $2,000, but I have proof that the other cars I got them alone by myself along with the house. The barbecue pit was during our marriage. The tools and the barbecue pit.
Okay. So where are the tools now?
¿Dónde están las herramientas ahora?
Aquí está en la casa todo.
They're all here at the house.
What type of tools are there?
¿Qué tipo de herramientas son?
Pues casi todo, no, pues nada, casi todo, nomás unas llantas que tiene y unas tapas de los rines, yo creo, porque toda la herramienta se la llevó su mamá.
Well, it's tires, lids, like for the rims, because all of the tools was taken by his mom.
Mr. Reyes, What tools
Sure.
are you talking about?
I have a little, like, it's has little tools in it. So it's a bag like with drills and things, socket wrenches,
Yes.
things for the vehicles like oil changes, and I had a gas butane tanks, a burner.
Okay, so butane tanks.
Yeah, and those rims, the rims were outside. I don't know if she has them still. Things that I own, that I bought.
You bought during the marriage or before the marriage?
It was before. No, well, it was. I had part of it, and and part there. I'm not gonna lie. But
Oh.
I can't. And the car, like she says, that I paid 1,500. I paid more than that.
Okay.
She.
Okay. So can you describe what you want to take so that I can give her.
I want my barbecue pit. Look, she can stay with the tools. Can I have my barbecue pit, the set of tires, and my car? And she can stay with everything else.
The car you already have it, no, the Challenger?
No, she hasn't. She hasn't given it to me. I try to get it with the police officer.
Hold on.
Nobody can.
One at a time.
Entonces, ¿qué es lo que estás buscando ahorita? Estoy buscando yo el asadero, mis llantas y mi carro. Ella se puede quedar con todo lo demás, incluyendo las herramientas. No has conseguido, ya el carro lo tienes contigo. No me he dejado agarrarlo. Yo traté de ir con un oficial.
Okay. Then you will pick up your barbecue pit, and that should be in good condition. You will pick up your tires and your wheels, and you will pick up your Dodge Challenger, 2012 Dodge Challenger.
Thank you.
Muy bien, entonces vas a poder ir a recoger tu asadero y debe estar en buenas condiciones, las llantas y los rines y el 2012 Challenger.
You, Ms. Canales, will be awarded the 2015 Chevrolet Impala. You will be awarded the 2014 Chevrolet Malibu. And everything else that is in your possession, if they happen to be the tools, then the tools are also in your possession. And anything else you have in your possession, your furniture, your car, whatever it is you have there.
Can I ask
Muy
you
bien.
something?
Ahora para usted, la señora Canales, se le otorga el 2015 Chevy Impala, el 2014 Chevrolet Malibu y todas las otras cosas que usted ya tenga en su pertenencia. Eso incluye las herramientas y los muebles y todo lo demás.
Mr. Reyes.
Sí, eso ya era mío antes.
Ms.
Yes.
Canales, I'm not asking you a question. Answer my questions only, okay? Mr. Reyes, go ahead.
Can she give me the title too of the car? She has it in her possessions. She
Okay.
took it out of the car.
Got it. Go
Y
ahead.
también le pido que por favor me entregue los títulos ya que ella los sacó del vehículo.
Ms. Canales, that includes the title to the car.
Señora Canales, eso incluye el título del vehículo también.
Está bien.
Very well.
Okay. Can we get that done by Friday?
¿Podemos
Yes,
finiquitar
sir.
todo esto para el viernes?
Sí.
Yes.
How do you want him to contact you?
¿Cómo quieres que él la contacte a usted, señora?
Pues por parte de su mamá, que venga su mamá por las cosas.
Well, through his mom. His mom can come pick up the things.
Well, it's going to have to be his mom and somebody else because she won't be able to get the barbecue pit and the tires and the wheels.
Bueno, tendrá que ser su mamá y alguien más porque ella no va a poder recoger el asadero, las llantas y los rines.
Está bueno, que venga él a levantarla si quiere.
Fine, he can come if he wants to come pick them up.
How does he want him to make arrangements? By text or by email or by phone?
¿Cómo quieres que él haga arreglos con usted? ¿Por mensaje de texto, correo electrónico o por teléfono?
Como lo quiero hacer.
However he wants to.
I recommend that if you do it verbally, that you also confirm it by text, Mr. Reyes. And
Okay,
Ms. Canales.
can I take a police officer because I don't want problems with nobody?
You
I
can
don't want.
take,
I get.
if the sheriff's office is able to, or the constables, then by all means.
Okay.
Muy bien. Si ustedes lo confirman verbalmente, por favor traten de confirmarlo por mensaje de texto también. ¿Podría llevar a un oficial conmigo porque no quiero ningún problema? Sí, si hay un alguacil disponible, puedes ir con ellos.
Very well. Your divorce will be granted in the manner in which you have requested, for the reason that you have requested. Marlene? Wait a minute. Ms. Canales,
Mande.
Yes, sir.
here that you want to go to Almaguer?
Aquí tengo que usted quiere cambiar a Almaguer.
Sí.
Yes.
And where does Canales come from?
¿Y de dónde viene el apellido Canales?
Es que él me puso, yo ya soy Reyes, era Reyes, ¿verdad? Pero él, en la licencia mía ya es Reyes, nomás que ellos me pusieron, como él metió la petición, me puso Canales.
Okay.
Y por eso me estoy identificando con Canales.
Okay.
Porque
well, my license is Reyes, but because he's the one that filed it, he filed it under Canales, and that's I'm identifying as Canales.
And where does Almaguer come from?
¿Y de dónde viene el apellido Almaguer?
Es de mi papá.
It's from my dad.
All right, then we will put Almaguer on there, okay?
Bueno, entonces vamos a poner aquí Almaguer.
Once I sign it and gets filed, you can take a copy of it and go and make your license change.
Muy bien, después de que yo firme el decreto, usted puede, y que lo haya tramitado, usted puede tener una copia y puede ir a cambiar su licencia. Very well.
Can I ask you something, Your Honor?
Yes, sir.
Meanwhile, I pick up the car. Can they not move it no more? Can they not?
Yes.
I'm afraid of.
I got it. Miss Almaguer.
Mande.
Yes, sir.
Please do not move the car anymore. Leave the car ready to be picked up by Mr. Reyes.
Señora Canales, por favor, ya no mueva el carro, déjelo listo para que el señor Reyes lo vaya a recoger.
Está bueno.
That's fine.
Thank you.
Gracias a los dos.
Good luck to both of you. Suerte.
Y buena
Thank you, sir.
suerte.
Can I be dismissed?
Yes, you're excused.
Thank you, sir. Have a nice day.
You too. Okay. Who else is left here? Any more? Romelita's iPad? Who's Romelia's iPad? And Jose Zamora? Okay, what case are you here for?
For the case 11223.
11223. Let's find out what.
Page 3.
First Bank National versus Maria Araiza and Oscar Araiza. Yes?
Yes.
Did anybody show up for this? Let me on page 3.
No, Judge.
There's nobody here on that case, man. We'll set it up for for November 1st, just for status.
November 1st. At what time, sir?
At 1:30.
Okay. Thank you.
Thank you, ma'am.
Judge, what was her name, last name?
What name? Romel?
Maria Zaira Araiza.
Maria Araiza. I'm sorry. Araiza, A-R-A-I-Z-A. A-R-A-I-Z-A.
A-R-A-I-Z-A.
Yeah, it's Araiza. Como no? I had a classmate there in Zapata that was Maria Elena Araiza. All right. Thank you.
That's my husband's cousin.
Your husband what? Cousin.
My
Okay.
late husband, her cousin.
Ah, okay. All right, good. We'll see you then. Mr. Zamora, what's your case?
Yes, Judge. Yeah, I was scheduled to show up for a hearing regarding a credit card debt.
Do you have the number of the case? Because we don't have it here of it.
Page 12, 11418.
Good. I'm wiped out here. Page 12. Synchrony Bank versus Jose Zamora Jr. Mr. Zamora, there's nobody here from them. They just filed the case, so it's new. So I'm going to give them one last chance to come here. And if they don't come here, then I'll dismiss it, okay?
Okay, sir.
So I'm gonna set you for November 1st at 1:30. If they don't show up, then we'll dismiss the case. Okay?
Okay, thank you, Judge.
Thank you. Send a notice, Mami.
Yes, Judge. Judge, there's two tax suits where they showed up, but we couldn't hear them. So JB Gonzalez is asking me if you can set aside the default so we can work with them.
Go ahead. But tell me which ones they are so you can put them on the record.
It's case number 10747.
Maria Juana Martinez. Apparently, let's put this on the entry, Irene and Elba. On 10747, we're recalling
Yes,
that
Judge.
case, recalling it because apparently the defendants were present. We marked them as not present, but they were present. They just could not unmute themselves. So we're going to set aside the default and set it for October 22nd
And 11150.
at 10 a.m. Same announcement for 11150, Simon Sanchez. We marked them not present, but they were present. They just could not unmute themselves. And we're going to set aside the default, mark them present, and set them for October 22nd at 10 a.m. Thank you. Okay, so I think we called all of the family. So now I'm going to go down to civil. Page 2. I think, okay. Eduardo Soto, Luis Elizondo.
Really have an agreement to reset, Judge.
Thank you. Synchrony Bank for Leticia Caldera.
Nothing.
She was served on November 2nd, or what is that?
21st. November 21st.
Motion for default. I don't know what's here. We're not going to move on the default and set them up for October 22nd for status. See if they show up. If they don't show up, we'll DWAP. CAZ Creek versus Luis Elizondo. Reset for December 6th.
Yes, Judge.
Thank you. Page 6, Caterpillar versus Villarreal Productions.
October 22nd.
Reset for October 22nd. Thank you. Synchrony Bank versus, was that an agreement or what?
We heard it.
The attorney was present, Judge.
They were present, Judge.
I'm sorry. Okay. 11392, Synchrony Bank versus Fernando Castillo. No one appeared, right?
No.
Carry on a call that was just filed. Let's give him one last shot on October 22nd. If he doesn't appear, we'll send notice. If he doesn't appear, we'll DWAP. Citibank versus Claudia Garcia. Service on 6:30. No one appeared. Send up for 10:22. If it send notice, if they don't appear, we'll DWAP. State of Texas versus 2014 Buick Veran. We did that, right?
Yes.
Eulalia Minor versus Tanya Esther Chapa. We had that. Somebody was there on the chat. It says Minor v. Chapa. But they never answered me.
No.
That guy, Rashun Phipps. I kept on saying Rashun Phipps. Send them up for October 22nd. Send them notice. If they don't appear, we'll DWAP it. PCA Acquisitions versus Juan Thatcher. No service yet. Set them up for November 1st. Send them notice. See what happens. Rene Guerra versus 21st Mortgage. They got removed to federal court. Thank you. The interest of Kivelli and Martinez.
Rule 11, agreement to reset, Judge.
Thank you. In the interest of A and V, EV.
Rule 11 to reset.
In the interest of, in the matter of Jose Olivares and Erica Olivares, 11374.
September 15th at 1:30.
By agreement. In the interest of Juan Alanis, a minor child. Flor Flores. I think we agreed to October 22nd.
There's a motion for continuance.
Yes, October 22nd. Granted, in the matter of the marriage of Daniel Arambula and Sandra Arambula.
Rule 11 agreement to reset.
Thank you. Yikes.
It's not 5 o'clock yet.
I know, but I know why I'm tired. I know if I'm tired, I can imagine some of you guys. I got my daughter's volleyball game at 5, so I'm good.
Says you're still streaming to YouTube, Judge.